I was actually reading Shashikant's judgment, and knew that is 2002, volume 5, SC 738. And my submission was that I was.
You had almost concluded reading that.
Yes, I have.
You are submitting that the observations therein are not correct in law.
But my
With regard to mandatory and direct.
my submission on that is that so far as it holds the 3191 part to be directory, that in my respectful submission is not correct. 3191 is the material provision.
And the rest of them are procedural.
Yes, the rest of the three are procedures as to how it is to proceed. Is my first submission regarding Shashikant. My second submission regarding Shashikant is, in any case, Shashikant is a case where the 319 order was passed at the correct time. And that is how the reference order has also distinguished Shashikant. But anyway, that's not binding, or that's neither here nor there. So therefore, according to me, Shashikant was a case where the order had been passed at the correct time. And therefore, Shashikant is entirely different on facts. Now, Shashikant has been relied 2 times thereafter. Both judgments are in the learned solicitor's compilation. I'll refer to them at a later stage just now. There is no further discussion on what Shashikant holds. Shashikant's principle has been picked up and applied twice again. First, it has been applied in 2002, volume 5, SCC 738. If your lordship feels your lordship can just, it has been applied in 2007, volume 7, SCC 378. I'll refer to these 2 judgments a little later, my lord. Let me first. So my second submission on Shashikant is that it is entirely different on facts. There the order was passed within time. Then, my lord, we come back to interpreting 3191 itself. Now, on that, my lord, I have just a small compilation. There is the Law Commission's report on the basis of which the provision itself was introduced. Your lordship may kindly have that report of the Law Commission. Where is the page? You need the paging. That is at page. Well, this is only the Law Commission's report and 3-4 judgments where the same principle that I'm saying has been. Just kindly have the last page 53 onwards of what the Law Commission says, my lord. At 54. 53 at 54. This is the 41st Law Commission report, on which basis section 351, which was earlier there, was amended and renumbered in the new code as 319. Now, the reason why I'm reading it is, this also says you can join him in an ongoing trial, not after the trial is over. The whole purpose of amending this section and introducing it as per the Law Commission was to enable the person to join in an ongoing trial. And therefore, Hardeep Singh is absolutely right in its conclusions, is my respectful submission. And my lord, I would rather say the principle in Shashikant, it does not even arise for your lordship's consideration, because Shashikant is a case where 3191 was passed at the correct time. Now, kindly have this bottom of page 54, my lord.
But earlier, 319 was amended, or it should unamended? Has it been amended?
Yes, 351 was altered slightly. And
that is prior to the 73 Act. CRP
no, under the 89 code, old code.
89.
Yeah.
So it was an amendment actually.
No. It is reintroduced in its present form after making the modifications which the Law Commission has suggested. Once your lordship reads this, your lordship.
What are the pre-amended positions?
My lord, pre-amended.
55 is pre-amended would be just.
Yes, there were only persons attending trial who could be joined.
Can we have that?
Yes, I'll just get it. Only a person who was actually attending. Once I read this 24.8, it will become clear, my lord. This explains the previous position and the new position. Let me read page 54 at the bottom. Okay. So, my lord, your lordship may have Hardeep Singh at 113. It quotes the earlier provisions. Hardeep Singh quotes it at page 113.
Correct.
Yes. If your lordship will have the judgment in Hardeep Singh, that is,
In the compilation, what is the page?
But in this compilation,
Page 22.
it is at page 1 of the compilation given by the,
Page 22.
Page,
internal-
internal page 22 of the
yes,
compilation.
yes, internal page 22.
What para, Patwale, any idea?
Para 10,
Ah.
para 10,
Yes.
para 10. In order to answer the aforesaid questions posed, it will be appropriate to refer to section 351 of the Criminal Procedure Code, where an analogous provision existed, empowered the court to summon any person other than the accused if he is found to be connected with the commission of the offense. However, when the new CRPC was being drafted, regard was had to the 41st report of the Law Commission, wherein paras 24.80 and 24.81 recommendations were made to make this provision more comprehensive. The said recommendations read: the 351 limited to this is the same recommendation actually.
This is the same recommendation.
Yes, this is what I mean.
Extract from that, those.
Yes. I can read it from there, but it was limited to offenders in court. Section 351 limited to offenders in court. But then let me read it from page 53 because the complete thing is there. 24.80 is reproduced. Let me read it from page 53. It's better. It's completely reproduced. Yes. Page 54 at the bottom. It happens sometimes, though not very often, that a magistrate hearing a case against certain accused finds from the evidence that some person other than the accused before him is also connected in that very offense or in a connected offense. It is only proper that the magistrate should have the power to call and join him in the proceedings. Section 351 provides for such a situation, but only if that person happens to be attending the court. He can then be detained and proceeded against. There is no express provision in section 351 for summoning such a person if he is not present in court. Such a provision would make section 351 fairly comprehensive, and we think it proper to expressly provide for that situation. Section 351 assumes that the magistrate proceeding under it has the power of taking cognizance of the new case. It does not, however, say in what manner cognizance is taken by the magistrate. The mode of taking cognizance are mentioned in section 190 and are apparently exhaustive. The question is whether against the newly added accused, cognizance will be supposed to have taken on the magistrate's own information under section 191C or only in the manner in which cognizance was first taken of the offense against the other accused. In concrete terms, if the original case was instituted on a police report, that is under 191B, will cognizance against the new accused be supposed to have been taken in the same manner as under section 191C? The question is important because the methods of inquiry and trial in the two cases differ. About the true position under the existing law, there has been difference of opinion, and we think it should be made clear. It seems to us that the main purpose of this particular provision is that the whole case against all known suspects should proceed with expeditiously, and convenience requires that cognizance against the newly added accused should be taken in the same manner as against the other accused. We therefore propose to recast section 351, making it comprehensive and providing that there will be no difference in the mode of taking cognizance if the new person is added as an accused during proceedings. Please note, this is of course necessary as already provided that in such a situation, evidence must be reheard in the presence of the newly added accused. The offense for which the newly added accused can be tried is not indicated in precise terms in the section. Obviously, the offense should be connected with the one for which the original accused is under trial, also present tense. To bring that out, a small verbal amendment is recommended. Section 351 should therefore be amended as follows, and then that 319 as it stands today is reproduced. And at page 57, ultimately, it is accepted by the Rajya Sabha. Page 57 at the top, second column, top right, clause 198 to 319 were added to the bill. So 319 is added by the Rajya Sabha. So, my lord, three parts I've already highlighted. At the top of the page, the fourth line, it is only proper that magistrate should have the power to call and join him in the proceedings. So the proceedings have to be live. Second, I have already said in the lower half of para 25.81, during the proceedings. And the third is when the proceeding is under trial. So therefore, my lord, that is how ultimately my lord, 319 as it stands, for the proceedings to be live, it is very important. And therefore, what Hardeep Singh holds is absolutely correct. And Shashi Kant doesn't take that away, because Shashi Kant is a judgment where 319 was passed in time. And your lordship was faced with a situation where, because of the person added going to court and getting an injunction, etc., the proceedings could not continue. And therefore, your lordships found via media that he should not be allowed to take advantage of his own wrong. Now, my lord, I have given in this compilation that I have just given to your lordships some judgments, my lord, where Hardeep Singh has been followed by your lordships, and some judgments of high courts only as a persuasive value, my lord, where your lordships will see where various high courts have taken the same view before and after. And if your lordship will have this compilation at page 1 is the judgment, my lord, of 2017 7 SCC 706. And I must say there is no added discussion. It's just Hardeep Singh has been followed. I mean, so far as the two judgments of your lordships are concerned, Hardeep Singh has been followed. And the first judge, your lordship may kindly have at page 8, para 10 of Brijinder Singh. Para 10 at page 8 says, it also goes without saying that section 319, which is an enabling provision, empowering the court to take appropriate steps for proceeding against any person not being accused, can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of 207, 208, etc. Then para 11, my lord, is the further what Hardeep Singh says, what is the evidence? And para 12, what is the degree of satisfaction required? Again, I am not actually going into all that, because then your lordships have said that your lordship
Beyond the reference.
Yes, your lordship will be sending it back. Though the third question referred is, I'll read that. That I submit is completely covered by the rest of Hardeep Singh. I'll come to the third question, my lord. So this is one judgment where Hardeep Singh is followed. Then, my lord, another judgment where Hardeep Singh is followed is at page 35 in 2021 itself. Yes. At page 35, if your lordship will see, that is not reported in SCC. So I have the SCC online citation for your lordships at page 35. Now again, the page 40, para 33, when the discussion starts, Hardeep Singh is considered. Para 33. While considering the rival submissions, the law on the scope and ambit of 319 is required to be considered. In the recent decision in the case of Sartaj Singh, this very bench has considered in detail the law on the scope and ambit of 319. In the said decision, this court considered the decisions of Hardeep Singh, Mohammad Ispahi, Rajesh, etc. Then, my lord, that decision is quoted extensively here. And after quoting it extensively, right up to page 48, then para 34, the ratio is laid down by the court. At page 48, para 34. It again follows Hardeep. And perhaps it would have to, because it's a two-judge bench and Hardeep is 5, so it would. The ratio of the decisions, para 34, on the scope and ambit of the powers of the court can be summarized as under. At page 49, clause 9. Again, my lord, after charge sheet is filed and before the pronouncement of judgment, except though it's the same, Now, my lord, some judgments of different courts, my lord, where similar view is taken, high courts, if your lordship wants, I can just quickly take your lordship through, or I have attached 5 or 6 of them, my lord, where there are all single benches of the High Courts, my lord, where 3 or 4 of them are before Hardeep Singh, also take the same view on a plain interpretation of 319. And the others are after Hardeep Singh, and if they are after, then naturally, my lord, they will have no option but to follow Hardeep Singh. So, my lord, my therefore respectful submission is that so far as 319 is concerned, the provision of the section itself is crystal clear, my lord. I have labored yesterday enough on it. I did not again labor on that, my lord. And it is conditional at the cost of, my lord, extreme repetition, my lord. I just 3191, where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being an accused has committed offence for which such person could be tried together with the accused. So that's the crucial part, my lord, together with the accused, and therefore the court has the power. Also, my lord, this section appears in that part of the code, which is chapter 24, which deals with general provisions as to inquiries and trials. That's the placing of the section. It is placed in the part of the code which regulates how inquiry and trial is to proceed. So if the trial itself is over, then there is no question of exercising power under 3192. And that I have said, when it is fixed for pronouncement of judgment, and after judgment, the court becomes functus officio. So that is one part. Now, my lord, I need to clarify one more functus thing, lord. And that is, my lord, the order by which the trial was separated. Kindly have that order, my lord, dated 28 September 2017. It is at page 537 of volume 2 of the additional document.
Judgment what you read also is that after trial and before pronouncement also it can be done. 362 was after judgment, no review, no change except clerical errors. But now, just to put the matter, in our case it may not arise because 3110 was the date when it was posted for judgment, judgment was pronounced. Let us say in a case, trial is complete, arguments are heard, the matter is posted for judgment. Because the provision 319, what you say is also is the power of the court to find out whether somebody has been left out deliberately to include that section. While assessing the evidence, the judge finds that somebody else should have been. At that stage, he does not pronounce the judgment. He says for further hearing.
Correct.
At
So
that,
trial revives.
it revives. So at that stage, it can be done.
Correct.
Just to put the matter.
So I was also, because there was a hiatus between posting the matter for judgment and pronouncement of judgment.
Correct.
So we were also discussing yesterday, and I would have said it a little later, that what happens if when the judge is sieving through the judgment and he finds that actually this man is
Correct.
it should be the main person who should be there. Then, my lord, according to me, he would post it for hearing, and then he would pass an order under 319 and thereafter proceed accordingly. Is that kind of a situation has occurred in a judgment, my lord, which is actually a one-pager. It is
Patwalia, just 1 second, 1 second. See, the language employed in 353 is 353.
yes,
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in the open court by the presiding officer immediately after termination of the trial.
or at some
But
subsequent.
that's all right. Supposing immediately he pronounces.
Then we are in my situation. Then according to me, he cannot do it.
No, he has an option to immediately pronounce. No,
Correct.
what I mean is, my brother asked a question. Now, does it make any difference at all? Because if he immediately pronounces on a future date, so once the hearing is complete and once it is posted for judgment, the only thing he can do is he has to pass a judgment this way or that way on the same day or on a future date after reserving the matter. Just to throw some light on this.
So on that, Manoj, what my submission is, if he passes the judgment, the crucial point is when he passes the judgment, because trial is over when he fixes it for judgment. Then we are in a situation where trial is over, but there is no judgment. So the court really is not functus officio. The court is still in session of the sessions case. This case will show. It's very interesting. But first, let me complete this. Then I'll tell your lordship how this case will show this problem. So he is still in session of the trial. So at that point of time, he has two options if he has not pronounced judgment on the same day when he has closed the trial. He can then repost the trial for hearing. And if he reposts the trial for hearing, he can pass an order under 319. Or he can pass a judgment. But according, in my respectful submission, the moment he passes a judgment, he in any case becomes functus officio. Then he cannot pass 319. Why? It has happened in this case, and that's why I'm showing these orders. What the learned judge does in this case, on 28 September 2017, he passes an order separating the 319 application and saying, I will continue with the trial. This I am separating. Now, when he separates it, in what trial is that application? So he numbers it as a miscellaneous application in no trial. So he says it will be numbered as a miscellaneous application. He has no power to entertain such a miscellaneous application. I'm going to read those orders just now. When the trial is over, he passes the judgment in trial number so and so of 2015. But then when he sits to decide the application, that trial is already over. So the order in the application is passed in a miscellaneous application number so and so. The procedure and the existence of the application is unknown to law. And this case is a very good example of that situation. Now, therefore, that's what I'm going to show to your lordships just now. Now, kindly have this order at page 537, where he separates the application from the trial, and then what happens as a consequence of that.
It's in which volume?
It's in volume 3, my lord, volume 2 of those additional documents. It's a thickish volume, yes.
And we can do that.
What page, Patwalia?
537, 537.
That's 87.
Yes, we have.
Now, kindly see at the top. It is ND, my lord, is the narcotic drugs. The trial number is 289 of 2015. Now, this order he passes. The case is at the stage of filing reply to the application under section 319 CRPC. Today, reply is filed. Perusal of the file shows the case pertains to the year 2015. 10 accused are facing trial in this case. Out of 10, 2 are on bail. Remaining 8 are in custody. The prosecution has examined all required witnesses. Further, the High Court has time-bound this case with a direction to complete the trial till 8th November 2017. And today is 28th September 2017. So because of application under section 319, trial will take further time. Present accused will suffer without any fault of them. So Elmad is directed to separate the application under 319 and register this application as a criminal miscellaneous. This cannot be done. For separating present trial and application under 319. So he separates the trial from the application from the trial.
What is it? What is it? So Almat is some post there.
Elmad is the court reader, my lord. It's
Court reader.
below the reader. The Elmad is, there is a reader and then there is an Elmad. The custodian of the record,
Yes.
so to say.
I thought there is somebody called Ahmad. So he directed Ahmad.
No. The restorer, Lord, who keeps the files. It's a restorer who keeps the files, Lord. He's called Ahmad.
Record keeper.
Yes.
Ahmad.
He's given a bigger degree than a clerk.
This is what a Punjabi word.
Correct.
Urdu.
He's a powerful man in the court.
In fact, most powerful person.
In commas only. So
Somebody like a Sharistar, we call it, is it? No.
No, Milord.
Solicitor is court reader.
He's court reader, Milord. In fact, he's the custodian of entire files of the
Yes,
court.
yes.
And Bombay solicitor is
Milord, in fact, he is having the key of the Almira where the files are kept. So he's the most powerful person in the court.
he issues notices, summons, everything Almas is doing.
court master.
No,
All right, yes.
So, my lord, just see. So, this order is completely illegal in my respectful submission. I am not a party at that point of time. I did not challenge it.
No,
but
here in this case, this one trial in the main case has not been concluded.
not on this date. No.
In this case,
Yes,
particular case.
yes, not on this date. No, in this case, trial is complete. Today it is complete. On the day when the order is
In this, the judgment you read, some application is filed during the trial.
correct. This very case, I am reading this very judgment.
What he does, he separates this application and decides to.
Where is the order passed on this application?
I am coming to that. I'll just give me 2 more minutes.
So
I'll read it.
that is passed on the same day.
No, that is passed later. That ultimately judgment is of 31st October and order will also be passed on
On
31st.
the same day.
Yes, same day. After. I'll read the judgment and the order.
Only one submission, Milord. In fact, the Honorable High Court had ordered that the trial be expedited.
Correct.
So the trial, only, I'm just giving the reason for bifurcating.
That reason is already reflected.
Yes, so that is there in the order.
He has already read that.
Yes,
He has read.
that is the reason.
So,
But the reply is filed by whom to this application?
the other accused, he issues notice in this application to all the other accused.
Not to you.
No. If your lordship will have page 536.
Well, as proposed accused, he is not summoned, he cannot appear, he cannot.
We are aware about that. There is a judgment by Justice Bobde.
Yes.
Yes. Which says that he should be given notice.
No,
He should
proposed
not be given
accused
notice.
cannot.
There is a judgment by Justice Bobde which says that notice is not necessary.
Not because he is a proposed accused, he cannot be like
I
156.3.
will cite that.
Like 156.3, he can't.
I will cite that where it says notice should be given. But anyway, I am not on that. That is neither here nor there. Not. We are far beyond that stage today. So 536 he gives he gives notice to the other accused. If your lordship will see the earlier order of 21st September, he says prosecution has filed an application. This is the first day when the application comes up. Where the order is at page 536. 1 page before. 21st September, the application is filed. So it is the first day it comes up. Prosecution has filed an application under section 319 CRPC. The other accused requested to give opportunity to file reply. Accordingly, the case is fixed for 28th September for filing reply. So on the second date itself, he then passes this order. Now, the second part of the order is equally interesting, my lord. I have read. So the Almad is directed to separate the application under 319 and register this as a criminal miscellaneous is unknown to law. It is doing violence to 319. He cannot separate it. The application is integral to that trial.
Let us read further.
Yes.
For separating.
For separating present trial and application under 319 CRPC, I rely on 1999 1 RCR Criminal 283. There is no judgment on this page. I have done my research. If I am wrong, my lord, the Learned Advocate General's office can find out. This citation is wrong. There is no judgment on 1999 1 RCR Criminal 283. There is no such judgment. But in any case, I think probably either the page is wrong or the year is wrong. We have tried to do 10 pages up, 10 pages down. Also, nothing could be found. So probably the year may be wrong, but that was too much of, I do not know which judgment he is relying. Now, where our own Honorable Punjab and Haryana High Court has held, one of the accused went abroad, not available, trial lingering, trial court directed to take appropriate action for splitting case. In any case, what he is relying on is totally different. That is not a 319 case where an accused is abroad. There, my lord, 3172 gives power to him to separate trial, and therefore that power can only be exercised in case of a person facing inquiry or trial. So therefore, this whole concept of separating trial in 319 is unknown to law. It cannot be done. I'll show 3172 also. So for separating present trial and application under 319. I rely upon 1999 1 RCR similar criminal 283, where our own High Court held one of the accused went abroad, not available, trial lingering on. High Court directed to take action for splitting the case. Further, as already discussed above, this case pertains to 2015. 10 accused are facing trial. 2 are on bail, remaining are in custody. Let APP request for adjournment for prosecution evidence. My mind, prosecution has sufficient opportunity. So I need not read the rest of it. The next steno of this court is directed to print 2 copies of this order. One is to be placed on this file, and this file is fixed for recording statement of accused under 313. Other copy is to be placed on criminal miscellaneous file, and criminal miscellaneous file is fixed for consideration of application under 319, which is fixed for 4th October, etc. So he separates it, which according to me he cannot do. It's completely illegal, this order. Then what he does, he decides the main case. Now kindly see the judgment in the main case. I just want to show the index and then one para of the judgment, because yesterday I said this application is not mentioned. I stand corrected. It is mentioned. So that is, judgment is in volume 3, R3, this very. Kindly have this volume, just have the very first page of the judgment. The judgment is rendered in session case number 289 of 2015. The application under 319 was filed in this session's case. Now, just kindly take page 9 of this judgment. I just want to show your lordships. It records that the para in the lower half of the page, after completing necessary formalities, Challan was presented against 10 accused by mentioning that investigation is pending against the remaining person, and after completion of investigation, Challan against them will also be presented. So there was only one more accused original. So there is his Challan is much later. It comes in 2019. So therefore, there is no trial or inquiry pending against him. Then kindly at page 84, where this application is mentioned, page 84, what he says in this judgment at page 84. Para bottom of the page. Learned APP further argued that during investigation it is transpired that kingpin behind the whole sequence was Sukhpal Singh Khera, who through his personal security officers Joga Singh and Manish and Charanjit Kaur were behind the curtain, argued that summoning these accused an application under 319 has been filed, which is pending for today. Then he records in brackets, application for summoning accused is also filed, which is separately registered as criminal miscellaneous because High Court has directed to dispose of this case, and which application this court is going to decide today itself by separate order. Now, this is absolutely incorrect. He has no inherent power of like a 482 or a 151 CPC. He is bound by the.
So this makes it clear that he has decided it after the
Correct.
judgment is pronounced.
Correct. That the second order also says that today I have already pronounced my judgment. That order will also say that. So therefore, now kindly have that order by which the application is decided, because that application is not being decided in this session trial at all. It is a separately numbered criminal miscellaneous. How is it even maintainable? Is the question, is the first submission, my lord. Just kindly see that order, my lord. That is at page 121 in the main paper book itself.
Page?
Page 121 of the SLP paper, the first paper. (121). Kindly see the top. Criminal miscellaneous number 339 of 2017, filing ID CNR, the trial number is missing. It was session case 289 of 15. So he's not deciding it in that session case at all. Because according to him, he's made it a separate standalone application today. This order is completely against law on this ground alone. Then he records this order of mine will dispose of an application, etc. On facts, I'm not going into it. Then he says at page 128, sorry, 130. As things stand out, this FIR was registered and Challan against 10 accused was presented by mentioning that after investigation, the Challan against the remaining accused will also be filed. Till date, no Challan is presented against the accused whose names are mentioned. By my separate judgment, all accused against whom Challan was presented, except one, are convicted today. Then proceeding was separated because High Court said decide quickly, etc. So, therefore, he also records that I have already decided that. So, my lord. So, therefore, my lord, the submission is that this order is completely against law. It is completely illegal because he himself separates it from the trial. Now, where is his power to separate? That is 317. Kindly have 317. When can he separate? 3172. And which trial he can separate? It is only against an accused against whom an inquiry or trial is pending. 317, the title is Provision for Inquiry and Trial being held. I'm sorry. Not this provides. 317.
Yes. Proceed.
Or 317 says provision for inquiry and trial being held in the absence of the accused in certain cases. One is not relevant, but for the sake of completedness, I will read it. At any stage of an inquiry or trial under this code, if the judge or magistrate is satisfied for reasons to be recorded that the personal attendance of the accused before the court is not necessary in the interest of justice, or that the accused persistently disturbs the proceedings in court, the judge or magistrate may, if the accused is represented by a pleader, dispense with his attendance and proceed with such inquiry or trial in his absence, and may at any subsequent stage of the proceeding direct the personal presence of such accused. Now, next is relevant. If the accused in any case is not represented by a pleader, or if the judge or magistrate considers his personal attendance necessary, he may, if he thinks fit, and for reasons to be recorded by him, either adjourn such inquiry or trial, or order that the case of such accused be taken up or tried separate. So under 2 says, if he thinks for reasons to be recorded, he has 2 options. Either he can adjourn the entire inquiry or trial, or he can, in the case of such accused, order that the trial be separated and taken up separate. But it is only against an accused who is facing an inquiry or trial. It is not an application under 319, because 319 says in the course of any inquiry or trial. Now, if you are application file, you are segregating it and registering it as a criminal miscellaneous, it's violence to 319, in my respectful submission, apart from anything else. So therefore, my lord, this is the second submission which I am making, why this order should be set aside. Then, my lord, I must also show your lordships one other order which according to me has no legal significance at all. But that is an order dated 31st October. He passes judgment of conviction, etc. He passes this order. Then he passes one more Zimni order, my lord. Kindly see that also. Or the third order which he passes on 31st of October. That is again the second volume R2 at page 547.
Page
547, that thick volume, yes. (547) kindly have arguments heard. Now again, if your lordship will see this, I'll read the first right from the one. In fact, in seriatim, this would be the first order. Then second is the judgment, and third is on that application under 319. He says no DW is present, neither opted to be examined. Arguments heard. Vide my separate detailed judgment of even date. No, this is the second one. Judgment is pronounced now. Arguments heard. Vide my separate detailed judgment of even date. Accused, the names are given, are convicted under NDPS Act, whereas accused Kala Singh acquitted. As accused Anil, alias Neelu, has been declared as proclaimed offender, so file be completed and consigned to the record room, be put up as and when Anil Kumar Neelu surrenders before the court or proceeds by the police. Contraband material involved stands confiscated, same be disposed of as per rules. Now he consigns the file to the record and says, whenever Anil Kumar's case comes, please put this up again. So according to me, this is not an order under 3172. Cannot be, because Anil Kumar is not even facing.
You know, what is the arguments heard?
Yes.
So this is prior to sentence or what?
Same day,
I
31.
don't know, bro. Everything is happening at the same day. Everything is
Mr. Patwali, actually, the judgment runs to 120 pages.
correct.
This is the 121st and 122nd page. See on top.
Yes.
It's
Yes.
part of the same judgment.
Yes, yes, yes. Your lordship is right. Absolutely right. In fact, I had missed it. Your lordship is 100.
It's
That
part of-
explains it.
Part of the same judgment.
That explains it. Correct. Therefore, he is not talking of 319 in this order because 319 will come later. In this, he is not talking of 319.
It's 121 is only a consequential order. Ah.
First line is no doubt DW is present, neither opted to be examined.
But this is carrying forward from the earlier date. If your lordship will have the
Yes, earlier also,
30th also he says, the day before he says, accused
it is
not,
not produced by the jail authority.
yes, accused not produced by jail authorities, no defense evidence is present. Learned counsel for the accused prayed for adjournment, same is granted.
So this appears to be prior to pronouncement of judgment. No DW is present, neither opted to be examined. Arguments heard.
These 3-4 lines,
Arguments heard while by separate judgment dated so and so.
actually, this is what we call that Zimini order, which they are putting in the
We
file.
call it Roznama.
Yes, these are
It's a part of order sheet.
yes, this is that short order in the file. How he could record 120 pages immediately like that is of course another question.
No, but there at the section 353(2) gives him three options. One is to deliver the judgment. Then it is taken down by the stenographer. Just see 353(2), etc. There are three different methods of pronouncing a judgment. 353. By delivering the whole of the judgment,
Or
by reading out the whole of the judgment, so that is different. By reading out the operative portion, where the judgment is delivered under clause A, the presiding officer shall cause it to be taken down in shorthand, sign the transcript. Therefore, it is possible for a person to dictate it in open court. Then that is the
Correct.
first method of
Correct. Yes. In fact, my learned friend points out that it is typed and pronounced on the same day because next to the judge, the stenographer's signatures also exist. So this will be by,
No, but whether those 120 pages are typed on the same day.
the only intelligent guesswork I can do is that it must be ready and then
No,
he must have,
because it appears that till 30th the trial is going on.
correct. On that day also trial is going on. So
On
he
30th, the defense witness is not ready. Some of the accused
Yes.
are not present.
Yes.
Are not produced.
So it was listed for DW actually on that day. And therefore,
And on 31st also the first order says that defense witness is not present.
correct. Correct. And he closes it by the procedure is quite alien, my lord. Insofar as my application under 319 is concerned, in any case, that is now today as decided as a standalone application. In no trial. That order is very crystal clear. So, my lord, I say that number one, that application could not have been passed after pronouncement of judgment on the first point. And number two, please see the way how the order has been made. It is not in that trial case pending before him at all. He has separated it and listed it as a standalone miscellaneous application, which in any case is doing complete violence to 3191. And therefore, this order should go on this ground alone. Now, my lord, I am almost done, but there are two judgments I want to show, my lord, which the learned solicitor has placed on the record, which I was going to show your lordships. But since he has placed them, I'll show it from there. Page 60 of his compilation. But I have only argued on the first point I have, on the quality of evidence, etc., etc.
That is not an issue.
Yes. I'm just trying to reassure myself.
You have not argued. You have substantially.
So,
60 of his compilation. 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 60 of his compilation.
That is a very, very strong point which I have. That's an extremely strong point which I have, I feel.
That's on merits.
Yes. Yes, 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 yes. Now, my lord, this at page 60 is 2007, volume 7, SCC 378. Here was a case, this is the case, my lord, where a 319 order was passed by the trial court in a case under 302, when the trial was still pending. That order was taken to the High Court. The person who was just to save time, I am just giving the facts in my own word. The person who was arraigned as an accused had been named in the original charge sheet, original FIR. When after investigation, police excluded his name, relying on 161 statements and relying on a plea which he raised of alibi. The trial court, when at the very initial stage, while examining the evidence when the trial was pending, passed an order under 319, arraigning him as an accused. He took that order before the High Court. The High Court set aside that order on the ground of relying on again 319 statements and his plea of alibi. After the High Court set aside that order, the trial court, on the basis of the High Court order, acquitted the rest of the accused. That order of the High Court, setting aside 319, comes before your lordships. Your lordships opines 161 was wrongly relied upon by the High Court to set aside the 319. Second, your lordship opines the plea of alibi is a matter of evidence. It is a matter of trial. The High Court could not have set it aside on the plea of alibi. Your lordship therefore sets it aside and sends the case back for trial. In the concluding part, your lordship also records, however, the High Court has, the trial court has relied upon the order which we have set aside to acquit the accused. That matter is pending in the before the High Court. Your lordship said that view of the High Court we do not approve, and then directed the High Court to expeditiously decide the appeal pending before. That is what this judgment is. It does not. It relies on Shashikant. Does not take. If your lordship will just have just 4 or 5 lines, and all this will become clear. Kindly have page 64, the last 4 lines on the page. Page 64, the last 4 lines on the page. The police, after investigation, submitted a charge sheet only against Daya Singh and not against Kapil Dev Singh. This is the gentleman. In the trial, the learned session judge Allahabad, in the trial before the learned session judge Allahabad, the statement of the first informant Rajinder Singh was recorded, where he specifically stated about the presence of Kapil Dev Singh and the role played by him in the incident. The prosecution then moved an application for summoning Kapil Dev Singh under 319 CRPC. The learned judge held that Kapil Dev Singh is named in the FIR, and the informant Rajinder Singh in his statement has corroborated the version given in the FIR, assigned the role of extortion to him, taking note of the relevant law on the subject, allowed the application by the order dated 26th May, directed Kapil Dev Singh be summoned to face trial. Kapil Dev then filed a petition under 482 for quashing before the High Court. I need not read the rest of it, my lord. At para 7, your lordship will come. Your lordship will know how the High Court allows it and what the Supreme Court does not find to be good. Para 7. The High Court had set aside that 319 order. The High Court has basically relied upon the statement of 6 witnesses which had been recorded by the investigating officer under section 161 CRPC to record a positive finding that the respondent could not have been present at the scene of commission of the crime as he was present in a meeting of Nagar Nigam at Allahabad. A statement under 161 CRPC is not a substantive piece of evidence. In view of the proviso to subsection 1 of section 162, the statement can be used only for the limited purpose of contradicting the maker thereof in manner known to the proviso. Therefore, the High Court committed a manifest error of law in relying upon inadmissible evidence. The next paragraph. That apart, the plea taken by Kapil Dev Singh in his petition under 482 was that of alibi. Section 103 of Evidence Act says burden of proof for particular fact lies on a person who wishes the court to believe so and so, unless it is proved by law that the proof of the fact lies in the person. Then second illustration, then your lordship said that's a matter of trial. Then, my lord, this is how the High Court allows it and your lordship says it is wrong. Then kindly have para 11, which is the only para where Shashikant will be referred. Having considered Having considered the submissions made by counsel for the parties, we are of the opinion that statement of witnesses under 161 being wholly inadmissible in evidence could not at all be taken into consideration. The High Court relied upon wholly inadmissible evidence to set aside the order passed by the session judge. That apart, no finding on plea of alibi can be recorded by the High Court for the first time in a petition under 482. As mentioned above, burden to prove the plea of alibi lay upon the accused, which he could do by leading evidence in the trial, not by filing some affidavits or statements purported to be recorded 161. The whole procedure adopted by the High Court is clearly illegal and cannot be sustained. Now, the other argument based upon the acquittal of co-accused Daya Singh has also no merits. The question as to whether an order passed under 319 would cease to be operative if the trial of the accused has been concluded has been considered in Shashikant. Then Shashikant is reproduced. Then it is said, therefore, the mere fact that trial of co-accused has concluded cannot have the effect of nullifying or making the order passed by the session judge as infructuous. Now, para 12 is very important. The learned session judge trying the case of Daya Singh seems to have been swayed by the fact that the High Court has not only set aside the order passed by the session judge under 319, by which Kapil Dev was summoned to face trial, but had also recorded a finding in his favor that he was present in the meeting of the Nagar Nigam, Allahabad. Since we are setting aside the order of the High Court, the aforesaid finding of the learned session judge would automatically go and cannot stand. So your lordships have allowed that revision pending in the High Court straight away by this one line. Then your lordship says, having regard to the facts and circumstances of the case and interest of justice, we consider it desirable that criminal revision filed by Rajinder Singh against the acquittal should be heard by the High Court as expeditiously as possible. We accordingly request the High Court to decide expeditiously, etc. Then it is allowed. So this is one case. This case is entirely different. Order was passed at the correct time. It was pending in the High Court. The trial, in fact, this is a situation where relying on the High Court decision in the 319 order, actually acquittal is made by the trial court. And therefore, your lordship said that we don't.
Just a minute. This last line of para 11, Mr. Patwalia. Therefore, the mere fact that the trial of co-accused Daya Singh has concluded cannot have the effect of nullifying or making the order passed to learned sessions as infructuous.
Correct.
So in this case, the co-accused stands acquitted. Now, if 319, once it is allowed, how will you try this person along with the other accused? Other accused is already acquitted. How do you reconcile this judgment with the...
So my point is that all this, according to me, this is distinguishable because number one here, 319 was during when the trial was active. That's the most crucial part.
No, that's right. In its origin, the order under 391 was perfectly valid. Now, by the time when it reached the Supreme Court, if the Supreme Court says that the acquittal of the other accused is of no consequence, so long as the acquittal of the other accused is not set aside, 319 4A is not going to be satisfied. He can't be tried along with the other accused. How do you reconcile this?
So according to me, my lord, this also violates 319 4, according to me. But I say your lordships in this matter need not go up that path because it doesn't arise here. And I have another point here. Why this law your lordships have laid down? fact situation and the repercussion in law if either way it is laid down as an abstract proposition. Let us say Shashi Kant today lays down an abstract proposition that trial can proceed even if they are acquitted. Will it necessarily also lead to a conclusion that therefore a 319 order can be made at any time, even if the trial is over? Perhaps it will not lead to that conclusion. But if a 319 order is made when it could be validly made, but the trial of that person gets frustrated either as a consequence of his own action when he challenges it, gets some kind of an interim order, or as a consequence of proceedings remaining pending, then your lordships in Shashi Kant is faced with a predicament. Now what do we do? Does he get scot-free? Then your lordships have laid down that law saying that all right, even if in the meantime trial is over, it will not have the effect. Kindly see this. Therefore, the mere fact that trial has concluded cannot have the effect of nullifying the order passed. So therefore, the mere fact that trial is concluded cannot nullify an order. But if an order is stillborn, could it then give it life by saying that because we have not nullified a valid order because trial is over, so therefore we apply the same principle to an order which is actually stillborn, and therefore we will also allow that order to proceed. That will do. The chapter 25 is procedure during inquiries and trials. Inquiry, Hardeep Singh relies on chapter and verse, which possibly the other side cannot challenge. Is inquiry after charge sheet is challan is present. So therefore, the chapter necessarily it is in that order. We go from investigation, then challan, then presentation of challan, then committal, and then we come to chapter 25, which is inquiry and trial. So therefore, my submission is Shashi Kant, actually I said yesterday also, if we go by the strict letter of law, then Shashi Kant's judgment, according to me, violates 319. But even as I say so, it is my submission in the same breath before your lordships but that is not an issue before your lordships, whether that is rightly decided or not. Because the crucial difference between Shashi Kant and my case is there the order was made in time. Correct. And therefore your lordships is correct. Yes. And it is not, according to me, it's congenital defect apart. That order is stillborn. It is illegal on the day when it is made. And see, so when you do something which is against the provisions of the code, then you are forcing your hand, and then other problems are arising. Order was to be made during a trial. You have registered it as a criminal miscellaneous. You are not a high court where you have 482 to register it as a criminal miscellaneous. You have no such residuary power or general power to do so. So therefore, because you have violated 319, you have no option but to do all that. So therefore, I say, my lord, where the order is in itself completely stillborn, Shashi Kant will not come to its rescue. And therefore, I'll read those 3 lines of the reference order also. Reference order also puts aside Shashi Kant, saying that is an entirely different fact situation, which does not arise here. And
see, ultimately it has to be a balance between the right of the victim and the person to be summoned.
Correct.
So please read para 20 and 21 on page 72 in the supplementary opinion of Justice P.K. Balasubramaniam.
Yes.
He has prettily put the object of section 319.
I will do.
Please read para 20 and 21.
Para 20 is the power under 319 of the code is conferred on the court to ensure that justice is done to the society by bringing to book all those guilty of an offence. One of the aims and purposes of criminal justice system is to maintain social order. It is necessary in that context to ensure that no one who appears to be guilty escapes a proper trial in relation to that guilt. There is also a duty to render justice to the victim of the offence. It is in recognition of this that the code has specifically conferred a power on the court to proceed against others, not arrayed as accused in the circumstances set out by the section. It is a salutary power enabling the discharge of court's obligation to the society to bring to book all those guilty of a crime. Exercise of power under 319 of the code, in my view, is left to the court trying the offence based on evidence that comes before it. The court must be satisfied of the conditions precedent for exercise of power under 319 of the code. There is no reason to assume that a court trained in law would not exercise the power within the confines of the provision and decide whether it may proceed against such person or not. There is no rationale in fettering that power and discretion, either by calling it extraordinary or by stating it will be exercised only in exceptional circumstances. It is intended to be used when the occasion arises, envisaged by the section, arises. I'm grateful. It says that must satisfy the conditions precedent in the provision. So, my lord, this is what I submit, my lord, that Shashikant and this judgment, in fact, don't stand in the way of my argument. And this actually doesn't even arise, really speaking directly, before your lordships in the present case. The only other judgment where it is relied is at page 130, my lord, of this very compilation. And here also, if your lordship will see, the order was passed within time. This had a the only reference to Shashikant, but this is on peculiar facts. There were a large number of litigation. Para 10 is the only para where Shashikant is considered. And it is just quoted and left. Para 10 at page 135. Time now to deal with the contention urged by Mr. Singhvi that expression could be tried together appearing in 319 means that the newly added accused must be tried along with the accused already sent up for trial. This question is no longer res integra in the light of judgment in the case of Shashikant, where this court was examining a similar contention. And then, my lord, Shashikant is referred to in para 13. In the light of the above, we have no hesitation in holding that even in addition to the is held to be justified by the constitution bench of this court, the mere fact that trial of remaining accused has concluded would not prevent the prosecution of the petitioner for offences for which he has been arraigned. So, my lord, these are the judgments. There is now one other judgment, my lord, which I want to bring to your lordship's notice, and that is 2004, volume 13 SCC, page 30. This comes shortly after Shashikant, and it is a judgment by the author of Shashikant, by the learned judge, Chief Justice Sabharwal, my lord, who is the author of Shashikant. And this comes shortly after that. And Shashikant is referred to. It's the short order of 7 paras. I just want to read it.
Almost all the criminal cases, they're all from Punjab and Haryana. Bhutta Singh, Machu Singh, and
Dharampal also, Dharampal was also Punjab.
Except one, you cited one case just now, that is from Gujarat.
Well, that is why we are premier. That is why we are premier. Punjab, we are premier families. Well,
Indication of law and order.
It's an indication of accountability also.
Examination under magistrates, candidate used to say, this doctrine has been laid down by the Honorable Supreme Court in Bath Singh versus State. Some name, something, very difficult to find out whether it is true or not. They will simply say, some Sarmeet Singh versus State, this has been held so like that.
Like the learned judge has cited 1991 one RCR. There is no judgment. That judgment is not existing 10 pages up, 10 pages down. So maybe the year is wrong. I do not know if the advocate general can find out from the original record or something.
but there are so many judgments, other judgments on this point. Because that is regarding the persons who absconded during the trial. So there are a lot of judgments on that fact that they can be dissected. Their trial can be dissected. This is what the learned court has referred to. So I can give some other judgment to Mr. Patwalia so that he is satisfied with the judgment.
No, I don't need to be satisfied.
And that order is not before this on.
With satisfaction.
Well, because
That has something to do with the application of mind by the learned.
well, that order is not there. Well, challenged before this honorable court. Anyway, well, that judgment will try to find out if the year is wrong. It's just trying to find it out.
Now, my lord, this is a short order. Just kindly hear. Leave granted. The appellants, leave granted. The appellants have challenged the impugned judgment of the High Court, whereby the Session Court has been directed to try the appellants afresh. The facts relevant for the present purpose lie in a narrow compass. In respect of an incident dated 14th April 90, various persons were charged for offences under 302-149 of the IPC and other offences. The appellants in this appeal were not made accused. They were, however, summoned under 319 of the Code of Criminal Procedure and were arraigned as accused after the entire evidence has been recorded and also after statement of accused under 313 had been recorded. Arguments were heard and judgment was reserved. Not only that, after the appellants were summoned under 319, the prosecution did not examine again all prosecution witnesses. Out of 16 witnesses, 6 were examined and police papers were also not supplied to them. The appellant and 4 others were, however, convicted for offences under 302-149 and other offences and rigorous imprisonment for life, besides fine of 10,000 was imposed in terms of the judgment and order of the Court of Session dated 29th June. Insofar as the 2 appellants are concerned, the High Court by the impugned judgment, after noticing the aforesaid facts, coming to the conclusion that serious prejudice has been caused to them, setting aside the conviction and sentence, insofar they were concerned, directed their retrial. The High Court, it seems, considered that at such distance point of time, many witnesses may not be available, directed that all witnesses examined earlier, if available, shall be re-examined after police papers are supplied to the appellant. As noticed earlier, incident relates to the year 1990. 4 accused have been convicted. Their conviction has attained finality. Section 319 has been construed by this court in Michael Machado and Sashikant. Applying the ratio of these decisions on the facts of the aforesaid applicants could not have been directed to be retried. Under these circumstances, we set aside the impugned judgment of the High Court to the extent it directs retrial of the appellant and uphold it to the extent it sets aside the conviction, sets aside the judgment and order convicting the appellant. So here what happened? 319 was moved, apparently, after everything was done and judgment had been reserved. But they were summoned and then the trial was opened again. As my lord was mentioning that if judgment is reserved and an application comes, then what happens? Trial is opened again. Out of the 16, 6 are examined in that very trial. And police papers were not supplied, etc., which was vitiated the trial. And your lordship said you can't do it again now. So it has to be done properly along with the other co-accused. Now, my lord, if your lordship will see the reference order, I'll just take your lordship to that and then make my submissions. if your lordship will have para 9, before I read that, my lord had said that how is the High Court dealt with it. Shall I just show your lordship that this part of the High Court's finding? The High Court actually, this argument in the main paper book, if your lordship will have, this argument is at page 15, starts at 15. High Court only relies on Shashikant and prefers Shashikant over her. Kindly have page 15. Page 15, the next submission, lower half of the page. The next submission of the learned senior counsel for the petitioners is that the trial court became functus officio on the date of the judgment, that is 31st October. In that connection, they cited paragraphs 37 to 39 from the Constitution Bench judgment in Hardeep Singh. They relied on para so-and-so, then other judgments also. Then from 16 onwards, the High Court quotes the order passed by the trial court. Sorry, it quotes Shashikant. Sorry, quotes Shashikant, and then, my lord, page 21, it says the decision in the case of Shashikant, page 21 in the middle, the decision in the case of Shashikant was not cited before the Constitution Bench in Hardeep Singh. To my mind, the decision in case of Shashikant is directly on the point involved as against the decision in Hardeep Singh. And therefore, in terms of the decision of Shashikant, the submission will have to be repelled, which I hereby do. So the contention is rejected relying on Shashikant, saying it is covered by Shashikant. Even otherwise, para 39 of Hardeep Singh would throw light. And it says to say that powers under 319 can be exercised only during trial would be reducing the impact of the word inquiry. It is settled principle of law that an interpretation will lead to. So this, he says, this the court was saying, it can be done during inquiry or trial. Now he's reading this to mean that because the court says it can only be done during trial, can be exercised only during trial, he's reading to say it can be done after trial also. Completely misreading it. And then para 22, page 22, he says, apart from that, a coordinate bench in Amarnath held that power under 319 can be exercised even after the judgment is concluded. In that case, the accused were acquitted by the trial court. After 4 months, the trial court exercised the power for summoning the accused. This court relied upon the judgment of Shashikant for that purpose. Present case stands on a better footing. Order was passed simultaneously, and the contention is thus rejected. Now, out of the judgment which I have cited and not read of the High Courts, there is a judgment of the Delhi High Court and Jharkhand High Court where it was exercised on the same day, like us. Both those High Courts have gone into the provisions of the code and said it cannot be done after judgment is pronounced, even if it is being done on the same day. So this is how the High Court deals with it. Now, your lordship may just come to the reference order. I have actually made a written submission on all three questions. So that I've given to your lordships, I'll just quickly glance over, take your lordships quickly over it. Not too much. I've already argued most of it. So therefore, that's my answer. But just kindly see para 17. The High Court has placed extensive reliance on the factual metrics. Sorry, the lordship has a reference order. Para 17. The High Court has placed extensive reliance on the factual metrics of Shashikant's case to draw parallels between the similarities in both cases. The summoning order in the former case was passed before the trial had ended, whereas in this case it is passed after the trial, that is after passing of judgment in session case 289. Therefore, this court, while dealing with Shashikant, interpreted the law based on the facts available therein, whereas the present case has a different context altogether. So even in the reference, your lordships have drawn that distinction. And then according to me, said that Shashikant, in this context, it is important to note that Hardeep Singh was first heard by two judge bench, etc. Then your lordship may come to the questions, my lord, which are there. At page 15, para 27, those three questions are framed. Lord. First question is whether the trial court has the power under section 319 of the CRPC for summoning additional accused when the trial with respect to other co-accused has ended and on the judgment of conviction rendered before pronouncing the summoning order. But Lord, I have already addressed your lordships on that. Therefore, I have nothing more to say on that, apart from what I have said. Two, whether the trial court has power under section 319 of the CRPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing or pending, having been bifurcated from the main trial. Now, the only provision to bifurcate is 3172. In my case, this situation does not arise. We cannot use absconding accused loosely here. The question is whether when the trial is bifurcated, when trial in respect of certain other accused is bifurcated. Now, trial will start after they are charged. When charge is framed, trial starts. I can even imagine the section 317 says even at the stage of inquiry. So at the very least, a charge sheet under 173 should have been filed against them. In my case, there is no such accused against whom who was absconding and whose charge sheet had been filed. There was one accused who was absconding, but in his case, investigation was continued. Investigation continued right up to 2019, when ultimately a charge sheet is filed in his case. He is arrested, charge sheet is filed, and that is registered as a separate session trial where not a single PW has been examined so far. Charge has been framed against him in that trial. Not a single PW has been examined. So therefore, my lord, I say in the facts of my case, actually this question does not arise at all, is my first point. My second point is this question will have to be answered in the light of a fact situation. Your lordships in the abstract cannot answer it. In abstract, if their trial is actually split up for some accused and the same trial in which 319 was filed remains pending, then perhaps something can be said that 319 could continue. But that has to be answered in each fact situation. In my fact situation, the fact that no trial remained pending is also clear from the order made in the 319 application. No trial, therefore he had to register it as a miscellaneous application.
But there is also a direction that in the case the absconding to surrenders or is produced by the police, case be reopened.
No, he says file is consigned to record, attach this file. Attach this file. Like if a decided case, your lordship calls for so many decided cases when your lordship is dealing with another matter. Therefore, I read that order and I'm very glad, obliged for this observation. Therefore, there is a material difference between saying file be consigned to the records and file be consigned to the records as and when that man is caught, this file can be attached. And in that case, perhaps the file was attached, but that's a separate case. Now, kindly see the distinction between this and 3172. There is a major, so many times when your lordship decides and finishes a case, your lordship calls for the records. It may be relevant to what that witness had said because the same persons will come into depose in that trial also. There is a material difference between 3172 and what has happened here. 317, kindly have 3172.
It's only when it's not represented by a speaker.
If the accused, 3172, in any such case is not represented by a pleader, or if the judge or magistrate considers his personal attendance necessary, he may, if he thinks fit and for reasons to be recorded by him, either adjourn such inquiry or trial, or order that the case of the accused be taken up or tried separate. So it's an inquiry or trial which can be separated. And my lord, in any case, in the facts of this case, that 31st October is of no legal consequence because factually that trial has never continued. That accused is now facing a fresh trial of 2019. So therefore, according to me, that order of 31st October will be of no legal consequence at all. Now, on the third question, my lord, what are the guidelines that the competent court must follow while exercising power under 319? Now, these guidelines are given in Hardeep Singh.
Hardeep Singh, they are elaborately.
They are elaborately dealt with. That what is the nature of evidence when it. So I wonder if your lordship would want to reopen. I am not asking your lordships to reopen that part of it, my lord, unless the other side says that something in Hardeep is wrongly decided, etc.
My contention is this, the subsequent order, the third question is not there. Three judges bench order on September order, the third question is not.
So therefore, we are all one, my
Third
lord.
question is really, kindly have a look at the order, dated number.
Correct.
Order date 5th
The
September.
solicitor is right.
Further investigation in light of the circumstances occurring in this case.
5th September, not.
So that was possibly for reference to the three judges bench.
No, it was an extract, Mr. Solicitor. Actually, that was only an extract. It is
Correct.
not fully extracted.
Correct.
Paragraph 26 and 27 of the order dated 10/5/2019 are not fully extracted. That's all. Just see the.
Yes.
We can't really say that it is an extract.
No, because, no, what is before is the last paragraph.
Correct.
Having considered the matter at length.
Yes.
Having considered the matter at length, we are of view that opinion expressed in this considered views occurring in this case in this. But the lordship would have extracted all the three questions. The fact
Lord,
that-
may I? Probably, my lord, the third is apparently for the above two. Guidelines for above two. 1 and 2 is the reference, and number 3 is guidelines for the above two. Probably it seems to be, my lord, the reference for that.
Correct. Guidelines under 319.
Yes, for the my lord,
319.
first two questions which are
But
answered.
in my respectful submission, Hardeep Singh gives sufficient guidelines.
So it is in
for 319.
continuation of first and second that the guidelines are to be laid down. This is probably, my lord, the reference.
No.
Because the Hardeep
What are
Singh
the
case,
guidelines and the components?
No,
Once
it is
follow
not.
through, it's-
Lord,
it's
Yeah,
not-
it's
first and
not
second, my lord, if first
It
and
is not restricted to that.
It's not
Lord, if
restricted.
first and second are read, my lord, probably because Hardeep Singh has laid down the entire.
What is that here? What are the guidelines that the
Competent court must follow it.
while exercising power?
But if it is to be read in continuity, my lord, it seems to be that. Of course, it is the prerogative of the honorable
I am reading all
bench.
the three questions.
But
I have only
then
suggested the
it
third
seems to be in
question.
continuation.
It's a third question really necessary. Because
It is not, my lord, probably.
It
It is covered, my lord. It is covered.
Yes, it is inherent in that.
That is probably why it is not extracted.
Only a-
Order.
There may be something, my lord, which I may just request may be added, my lord, in Hardeep Singh's case. Otherwise, it entirely, my lord, covers everything. Hardeep Singh is a.
So, my lord, so far as my submission is concerned, my lord, what is the nature of evidence? Yes, my lord.
Please conclude, I think you have concluded.
I have concluded.
We will hear the others.
Yes, absolutely. So third question, my lord, I have made a written submission. I'm only saying it's already covered by what Hardeep Singh says. My lord. I will only conclude by saying, my lord, that there is no
As Fiscal said, the answer to question number 1 will be the guideline because that will be the law declared.
Correct. And 2 also actually is different fact situation. In my fact situation, there is no absconding accused against whom an inquiry or trial is pending. I'm very grateful, my lord. If I have anything else to say. Yes, before I conclude,
But
my
in the
lord,
reference order, there is no mention as to why Hardeep Singh is bad.
there is nothing. So it's only they don't say Hardeep Singh is wrongly decided. Reference order says some clarification.
Further enunciation.
Yes, if your lordship will have,
Last paragraph.
yes, para 21 is the one.
Page 3 of the second order.
All right, page 3 of the second.
The order passed by the learned 3 judges.
Correct. On the other hand, having considered
Having considered the matter
at length,
of the reference order is why they say it should be considered.
correct. I'll read that also.
Para 23.
Summoning order passed after pronouncement of the
The 2 judges order.
Yes.
Page two. So now there is a judgment.
So, my lord, if I can read first this last para and then para 23. Considered this, I'm now reading that second order. Having considered the matter at length, we are of the view that opinion expressed in Hardeep Singh, which is Constitution Bench judgment, needs further enunciation in the light of circumstances occurring in this case. In this regard, it is appropriate that a Constitution Bench clarifies the same. Now, in para 23, in fact, earlier the court also said that Hardeep did not have an opportunity to cast any light about the validity of summoning order pronounced after passing of it. So that's the part which really the honorable judges thought that your lordship should be seen. Now, my lord,
You read which para?
para 23 of the first reference. Page 13, type at the bottom.
Then it appears that they missed out para 47.
Correct.
Unfortunately, the answers in the last paragraph to question number 1 and 2 are not specific.
Correct.
They
47 is very crystal clear. It is only till judgment, and that is consistently followed. I have attached 2 judgments, one immediately after Hardeep and one as late as in 2021. There are other orders also where it is being followed. In courts, it is being followed. Now, my lord,
insofar as the High Court is concerned, between the judgment of learned 2 judges and the Constitution Bench,
correct. That order is on the face of it bad. That cannot be sustained.
the High Court
And
is
it reads-
bound by the Constitution Bench.
Yes. It reads,
And even if para 47 is considered to be an obitur, as far as High Court is concerned, the High Court is bound by it.
correct. 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 Actually, it is the ratio according to me, Lord, but in any case, even if it is assumed to be
There is
arbiter.
some doubt because of the last
Correct.
answer.
Para 117.
Correct. Para one.
See, what is said in para 47 is not incorporated in
117.
117.
Correct. Now, my lord, just one last thing. The solicitor is here in the PMLA case, but if your lordship is not going into the facts of that case, or if he's not going into the facts, because otherwise the facts are very.
Let him say.
I'm not going in the facts, I'm only on law, my lord, as far as.
on these two questions that, then I need not go.
Accepting a stay refers to the tax.
Just
All-
one second. Nagamuthu, you are giving in favor of what Patwali said, then you can make a submission. Or you are with him.
I'm neutral.
No, no, you are not neutral. You are-
Take some side.
I am disappointed, my lord. I thought he was on
As a
some side.
neutral man, we are also neutral, but you have to say something.
To some
Mr.
extent.
Nagamuthu would like to go a step further and say that 319 cannot be exercised without noticing the proposed execution.
Brief submission, then we will hear well. We will come this.
Lord, I appear in one of the petitioners, Lord, SLP, and I wish to take some submission. Lord,
Wait, we will hear.
after my senior colleague.
We will hear, yes, but it should be very brief.
Very brief and only in addition to
So
what
now we have understood.
Yes.
Let us.
Lord, I may not take more than 5 to 10. No. Well, it is agreed, not to put this on the report, the Hadith is very comprehensive enough now to cover all the points under section 390. Now, there are 3 issues not raised. Issue number 1, well, question number 1, you have to highly consider whether the trial court has power under 319 CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of the conviction has been rendered on the same date before pronouncing the summoning order. So the question says, well, summoning order came later, acquittal order came first. So after the acquittal of the accused who are already facing trial, whether the summoning order can be issued subsequently when there was no proceeding pending. Well, this has been answered in Hardeep Singh, therefore the question can be very simply answered that Hardeep Singh covers it. Hardeep Singh says, power under section 319 can be exercised after taking cognizance, not before, and until judgment is pronounced. Hardeep Singh says, so here judgment has been pronounced, and after judgment has been pronounced, as per Hardeep Singh, new order can be made in section 319. So this can the question can be very simply answered in that way. The question is whether in this given case, the 319 order was passed when the proceeding was pending or after the termination, a question of fact, which cannot be gone into by this order, which is my humble submission. This is to be gone only by that court where the matter is actually pending. But the question is, there was one question interestingly raised. When the proceeding gets terminated, the argument is as soon as the arguments are over, as per section 353, the trial gets terminated. And therefore, if any order is made in section 319, after the arguments are over and before judgment is delivered, that itself is.
No, that is not Mr. Patwale's argument.
That is the argument.
No. He says that once the judgment is pronounced, then the court becomes compel officio. He also agreed that in the event the evidence is complete, the matter is argued, the judge goes through the papers and before the pronouncement of the judgment, he finds that there is some material against the proposed accused, then at that stage a power can be exercised. Have I understood properly?
Because then the trial will be reopened. Necessarily the trial will be reopened.
In the referral order, yesterday he referred to section 353 to say that the trial is over, if the trial is over, the moment arguments are, that was his argument. The referral order also says the same.
Yes.
The referral order also says the
So
same.
the trial is over the moment the matter is kept for orders. When the judge says arguments concluded, judgment reserved, trial is over. That's one part of it. That's the CRPC is clear. Then the observation came. What happens if the trial is over but judgment has not been pronounced? And he finds that there are some people who needs to be arraigned. Is he powerless? My submission is no, he is not powerless. He is not powerless because then he can reopen the trial because then it is still within his
I think that once the judgment is pronounced,
then it is
hands off.
correct. So if the trial is over, but he is still in session because he has power to reopen the trial.
After the trial is over, he examines the evidence,
Correct.
he considers the argument.
Correct.
And at that stage, he finds that no, somebody has to be proceeded further.
Then he will reopen
the trial.
and then pass an order and continue.
He has a suo motu under 390.
Yes.
He can always, that is an inherent with every judge who is dealing with the case.
Now, in the referral order, you have to kindly see there was an argument advanced. That is, one case is kept for judgment, then after that there is no power.
But then he has fairly, even now he is.
Now, if we concede, we got no difficulty. If we concede. So this is regarding question number 1. That's, therefore, not in my written submission, the report to section 232, 235, also to say that the proceeding get terminated on the pronouncement of judgment. But if it is a case of conviction, not even by the pronouncement of judgment or conviction, until sentence is
Sentence is
imposed.
Yes.
Because proceeding continues, evidence can be let in respect of the question of sentence. Accused is to be heard. So until Murad sentence is imposed on the accused, proceeding is pending before the set court. That law, Murad, has been laid down by 3-judge bench of this honorable court in 1995, 2 SCC page 513, Ram Naran case, Murad, paragraph 12. They very elaborately dealt with the same. 1995, 2 SCC 513, paragraph 12. So this is on the proposition, Murad, that
Have you ever referred to in this chart that judgment Ram Narayan? No.
Ram Naran is not true.
What is that judgment?
1995, 2 SCC page 513, paragraph Murad 18, 12, paragraph 12. But 12 and 30.
2 SCP.
Page 513. Pronouncement of judgment. That's the point. What me really comes to paragraph 12. Paragraph 12 minutes, page 523. Chapter 18 relates to trial before a court of session. Section 225 to 220 relate to stage prior to the framing of charge. Section 228 provides for a framing of charge against the accused person. If after the charge is framed, the accused pleads guilty, Section 229 provides that the judge shall record a plea and may in his discretion convict him thereon. However, if he does not enter a plea of guilty, Section 230 and 231 provide for needing of prosecution evidence. If on the completion of the prosecution evidence and the examination of the accused, the judge considers that there is no evidence that the accused committed the offence with which he is charged, the judge shall record an order of acquittal. Murad, this is 232. Seldom it is used, Murad, by the trial courts nowadays. 232. When all the witness turn hostile, there is no need, Murad, to put questions under 313 or to call upon the defense to examine any witness. Straight away the accused can be acquitted. Murad, the distinction is this is an order of acquittal, not judgment of acquittal. It's an order. 232. The court shall record an order and simply acquit by writing in one line that there is no evidence. So, if this is 232, if on the completion of the prosecution
There
evidence,
is nothing for 313. No, there is nothing for everybody is hostile.
there is no incriminating evidence,
Nothing.
no giving a benefit of doubt, simply acquittal. This is by means of an order. The distinction Murad is under section 232, it is an order of acquittal. Whereas under section 235, it is a judgment of acquittal. Judgment Murad should contain all the details as are prescribed in section 353 and onwards. Last title, issue, so many things Murad are prescribed in section 353. You not kindly help. The 354 language and the contents of judgment, except as otherwise expressly provided by this code, every judgment, not an order, every judgment referred to in section 353 shall be written in the language of the court, shall contain the point or point for consideration, the decision thereon and reason for decision, shall specify the offence of which and the section of the Indian Penal Code or other law under which the accused is convicted and the punishment to which he is sentenced. If it is to be judgment of acquittal, shall state the offence of which the accused is acquitted and direct that he be set at liberty. When the conviction is under section of the Indian Penal Code and it is doubtful under which of the two, it goes like that. So this provision section 354 is not applicable to section 232. It is an order, it's not a judgment. There is a vast difference between these two. Now, reverting back to the judgment in Ram Naran, paragraph 12, middle, the accused would have to be called upon to enter if the judge does not record an acquittal under section 232. the accused would have to be called upon to enter on the defense as required by section 233. After the evidence in defense is completed and the argument heard as required by section 234, section 235 requires the judge to give a judgment in the case. If the accused is convicted, subsection 2 of section 235 requires the judge shall, unless he proceeds in accordance with the provisions of section 360, hear the accused on the question of sentence and then pass sentence on him according to law. It will thus be seen that under the code, after the conviction is recorded, section 235(2) inter alia provides that the judge shall hear the accused on the question of sentence and then pass sentence on him according to law. The trial therefore comes to an end only after the sentence is awarded to the convicted person.
Yes.
Perfect.
So therefore, Murad and
Nagavantu, section 232, does it use the word order or judgment?
order,
Order of acquittal.
order of acquittal. Document really have a look at it.
Because a judgment was.
If after taking the evidence for prosecution, examining the accused and hearing the prosecution and the defense on that point, the judge considered that there is no evidence, in that the accused committed the offense, the judge shall record an order of court, not a judgment. Therefore, 353, 354 are not applicable. 313 questioning is not there because there is no incriminating evidence. Straight away, by single line, the court can say that there is no evidence. Therefore, I am recording an order, acquitting him. That is enough.
For how many decades this provision has not been exercised?
In some judgment, in our High Court, we highlighted this. And we also told the judges in the Judicial Academy, but
They're scared.
it is strictly followed.
They're scared to use.
Statements.
But it will reduce the time of the court.
We see some of the convictions recorded only on the basis of 161 statements.
Yes, yes. That is also there.
It is, I know of cases where 313 statements are not recorded in the person's expectation. There are some cases, at least in Gujarat, where 313 statement is not recorded because there's nothing to be asked and they're acquitted. Now, these 232 provisions are followed in, at least in Gujarat. I don't know about Tamil Nadu, but
It is not followed.
At least in Maharashtra it is not followed.
Followed. Yes, yes.
many cases, so many cases, those cases don't come up, my lord.
They are acquitted before 330.
Actually, you can.
There's no evidence.
Time if we apply all.
Yes, we can save the
Those
time.
cases don't come up to the High
You
Court.
can save time, but you can't save the judicial officer then. That is also a problem.
So that is what I intended to say, but I thought that it was not appropriate for me to say this before this honorable court.
They are afraid.
But
They are
I
afraid.
take a different view, and they may issue memo calling him upon to explain that why you have not written a judgment. That is why they are afraid. But therefore, I would request this honorable court to declare that this procedure can be strictly followed. Because statutorily it is permissible for them. They are afraid of reading. They are afraid of reading. That's even in respect of the Arnesh court case, you lordship knows more that when there is no material available to remand the accused, but the magistrates still, even today, they remand. They do not want to run the risk as it was pointed out by Honorable Justice VRSP. They do not want to run the risk. That's a problem. So therefore, in
If all of them follow all this,
Yeah.
then all of us will be running out of business.
We also will.
as it may be.
We also will.
So therefore, my fervent request would be, at least in this case, we ought to kindly declare that section 232 may be used in appropriate cases by the courts.
But that is not a point for reference. Again, you will
Yes,
find
yes.
with us.
There may be an observation made by the honorable court.
All this.
So
Yes.
therefore, my humble submission so far.
There is evidence, they start using it.
Therefore, in a nutshell, the trial comes to an end only upon sentence,
Sentence or acquittal.
acquittal.
Until the trial goes on, until then the court has got power under 319,
Even if it is reserved for judgment, still the presumption is trial is going on.
trial is going on. Because on conviction, the accused is to be heard and the accused has the right to lead evidence. Under 235(2), he has got power, right to lead evidence. So therefore, my humble submission, this has been held by the three judges. Trial gets over, but sentence is important until then.
Even if the judgment is reserved, still there is an opportunity to
Open it.
reopen the case.
Then 311 can be filed by the accused at any stage.
What provision?
311 can be filed at any stage. Like civil case, there is no provision here to reopen at all. In CPC, there is a provision to reopen after the case is reserved for judgment.
Yes.
But in CRPC, there is no such provision enabling the court to reopen. There is no need, necessity. But the accused can very well file an application under section 311 at any stage of the trial before judgment is pronounced. And there is no question of reopening. Question is whether to allow the petition or not. You know,
That's different, that's different.
Yes.
That is on the merits of the.
merits. So there is no question of reopening. Yes, 311. Pending. Any court may, at any stage of any inquiry or trial or other proceeding, under this code, summon any person as a witness or examine any person in attendance, do not summon as a witness or recall or re-examine any person already examined. The court shall summon and examine or recall and re-examine any such person which evidence appears to be essential to the just decision of the case. But when the matter is under consideration for preparing judgment, the court finds that some important witnesses have been omitted. So motor court can do under 311. There is no question of reopening. The suo motu power of the court under second part of section 311 gives suo motu power and it compels the court also. So therefore,
So after the judgment is reserved,
yes,
now after going through all the materials, the magistrate may feel he wants to summon somebody.
yes, he can,
311.
he has to, not only he can, Murad. There is an obligation on his part to summon. Second part, first part, no discretion of 311. So for a second part is concerned, it is obligation, it is necessary. Let me kindly have a look at any court may, first part. At any stage of any inquiry, trial or other proceeding under this code, summon any person as a witness or examine any person in attendance. Do not summon as a witness or recall and re-examine any person already examined. This is the first part. Then second part, and the court shall summon. Second part, the court shall summon and examine or recall and re-examine any such person if his evidence appeared to it to be essential to the justification of the case. A witness already examined can be recalled. A witness who was not examined can be summoned afresh.
At this stage, he can even issue 319 also. Why not?
Yes, based on that evidence.
Based on that.
Based on that,
Or whatever. Yes.
based on that evidence. He can summon somebody, he can examine, promote his evidence if he finds that some person has been omitted, who should also be tried along with these people, then he can be summoned based on that evidence. So therefore, in conclusion, my submission would be that trial gets over the moment judgment of either acquittal or imposing sentence is until then 319 can be.
So you also agree with Mr. Patwalia that once the sentence is imposed,
Yes,
319 cannot be invoked.
yes. Yes, Mother. So it's a question of fact. In the given case, it's a question of fact. Whether sentence was imposed.
So no, the question, one of the questions posed is the same question.
Yes.
Whether after pronouncement of judgment,
After
whether 319 could be invoked or not.
Brother Hardeep Singh itself says that after pronouncement of judgment, the power of 319 is not available.
Typically, that is said in para 47, but not in the concluding paragraph.
Then, Murad, we move on to the second question, Murad. The second question is whether the trial court has power under 319 CRPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing, pending, having been bifurcated from the main trial. But my answer is, it was also argued by him.
It is more an academic, not arising out of the facts of this case, perhaps.
Yes, ma'am. Being academic minutes, the answer would be, my humble submission would be, but the evidence recorded in a particular case is to be taken into account, not in some other case. If my lord was also pleased to pose a question to him yesterday, whether such a petition of 319 is filed in a split up case, what will you do?
Yes.
Then he fairly considers that he has to face.
Yes.
So the evidence recorded in a particular case alone can be taken into account, not the evidence either recorded or to be recorded in future can be taken into account.
Yes.
So in this case, Murad, the evidence already recorded.
Except under section 45 or 145 of the Evidence Act. What is that?
That is for the purpose of contradiction. No, Murad, I will come to the later. Now, Murad, what is the evidence to be considered? Murad, the evidence which has been recorded already in this given case.
What you are suggesting is,
Yes.
in the, let us assume, and there is an absconded, yes, absconding case.
Yes.
In that case, material should come to summon a person under 319.
Yes, in
Fresh
that case.
material. Not in this case, concluded case.
This evidence cannot be used in that case, Malad.
Yes, you are.
Because under section 273 CRPC, evidence means evidence recorded in the very presence of the accused.
Yes,
Here, Malad, the upcoming accused not present here.
yes,
Therefore, the evidence recorded in this case is no evidence in that case.
yes,
In that case, all the witnesses are to be examined afresh in civil examination.
yes.
And cross-examination also. In that case, Murad, if it turns out that these people are also involved, based on that evidence, Murad, not on the 161 statement, not on the FIR,
Yes,
based on that evidence recorded in that case,
Yes.
he can be summoned. Not based on the evidence recorded in some other case.
Even Nagamatu, in reality, all the witnesses must have been fully trained, no? When they go to the second trial.
There is a danger also.
Unless the opposite side wins, you know.
Murad, that is why, Murad, the evidence recorded already can be used as a previous statement to contradict.
Yes.
It can be used for corroboration. It can be used for contradiction. Murad, 145, Murad,
Under
157,
section
Murad, things of
145,
corroboration.
confronted.
But this evidence cannot be previous evidence, cannot be used for corroboration because there are two conditions laid down in section 157. 157 says not any former statement, not previous statement. Any former statement given to a person legally competent to investigate. That statement can be used. You not kindly see the language while read. In order to corroborate the testimony of a witness, any former statement made by such witness related to the same fact, utter about the time when the fact took place, or before any authority legally competent to investigate. Here, the trial court is not investigating. Therefore, the evidence recorded already would not fall under section 157. Therefore, the prosecution cannot use that statement recorded in this case in the future case for any purpose.
Or to the limited extent and on 145 for to contradict.
That is by the accused.
That's all.
That is-
By the accused, yeah.
If he turns hostile by the prosecution. 145 does not put these two conditions.
Yes.
145 is very plain in language. It says any previous statement can be used to contradict the maker when he is examined as a witness in a subsequent proceeding. Here, Murad, these statements recorded in the first case are all former statements, which would squarely fall under section 145, which can be used by the accused or the prosecution to only to contradict.
And why do you draw this contradiction only to test the creditworthiness of that fellow?
Yes, yes.
For a limited extent.
Yes.
Whether that fellow is dependable or not.
Section 155, Murad. Section 155, how to impeach the credibility of a witness. One of the ways Murad used to prove by proving the former contradictory statement. 155.
That's a contradiction.
Impeaching credit of a particular witness. The credit of a witness may be impeached in the following ways by the adverse party or with the consent of the court by the party who calls him. By proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. So I am contradicting under 145. I prove the contradictory earlier statement. Therefore, the credibility of the witness is impeached under section 155. For that purpose, not the accused can use it, not for any other purpose.
Only if he resiles from that.
No, but that will.
If he's saying something contradictory to what he has said in the
Yes.
earlier trial.
But 140, I need not go to it will take some more time. How to contradict, I need not go into that part in this.
That's all right, that record, you know.
I'm not
You
going
know
to-
that.
There are two parts in section 145.
Those who have practiced in the trial court know all these things. Not directly who come to Supreme Court.
Don't lay down the law.
25 years of experience in the trial court.
Yes.
Little I know. I'm sorry.
No, in this case, already an application has been filed and this order has been passed, which is a subject matter now. Now there is another trial which is going on.
No, not.
Now, in that trial, if the evidence comes up, is there a bar to file a similar application?
Similar application can be filed there.
Can be filed.
That is a different evidence.
Provided that evidence
That
comes,
set of evidence.
that evidence,
It can be.
Evidence should come afresh in that
I agree with that.
can,
It can be.
so that can,
Samrat, that is in respect of second question. But third question,
Mr. Naragutu remembers all my concessions very clearly.
Patwalia, trial court practice should be made mandatory for all the lawyers, not very directly government coming here and taking some interim order and walking away.
With my
honorable judges have the rich trial experience. Sitting in this bench, one of the honorable judges I know has got rich trial side experience, but on the civil side.
But trial side does not get you money. That is why we land up here. Tell us.
Yes, Murad. Regarding third question, both the sides said that Hardeep Singh is very comprehensive and therefore further guidelines are not required.
Yeah.
Murad, at least on two issues, Murad, there may be some addition. Number one, Murad. Question is, Shashikant Singh case, Murad, we say, question also arose yesterday. Suppose the accused is active, trial is pending, 100 witnesses have already been examined. Now, at that stage, Murad, one accused is added on a section 319. Now, whether de novo trial is to be conducted in respect of all the accused, in which case the evidence already recorded will not be, cannot be considered. Fresh evidence is to be recorded. Those 100 witnesses are to be examined afresh. It will be laborious. It will be unfair, Murad, so far as the existing accused are concerned. To ask them to face the trial again, to cross-examine the witness again, all these things. So, but practically, what is happening, Murad, in this country? Murad, whenever an accused is added, he is tried jointly, necessarily and compulsorily with the existing accused. That is why this problem arose. Yesterday, my lord was also pleased to ask me what will happen to the earlier evidence. The section 319 says that de novo trial so far that person is concerned.
Such persons.
Which means not the newly added person. Therefore, my senior friend was referring to section 317, we say that you can split up the case. 370, with great respect, 370 won't come at this stage at all. What is the relevant provision of 223? Without my kindly consider 223.
Yes, 223.
Right. Yes. What person may be jointly, may be charged jointly. The following persons may be charged and tried together. What my kindly convince. Charged and tried together. Namely, persons accused of same offence committed in the course of the same transaction. Persons accused of an offence and persons accused of abatement or attempt to commit such offence. Persons accused of more than one offence of the same kind within the meaning of section 219. Then formula D. Persons accused of different offences committed in the course of the same transaction. But the court has got discretion to have a joint trial of all these accused who fall under any one of these categories. But it is not mandatory that there has to be a joint trial in every case. It is a discretion of the court. For the sake of convenience, this discretion is used to have joint trial in every case. The accused has got no right to demand for a joint trial in any case. It is a discretion of the court. Suppose, under section 319, one accused is added. The court has to, at that stage, decide whether he should be tried jointly as per this provision along with the rest of the accused or not. He has to decide. If he decides, yes, it is better that he be tried jointly along with other accused, then, my lord, this problem will arise. All the witnesses are to be examined afresh. Suppose the learned judge decides, no, it is not necessary. He can be tried separately as per section 223. He will be tried separately because 223 is an exception to section 218.
But 372, 317.
Yes, I will come to that point. Therefore, under this provision, at that stage, court has to decide whether to have a joint trial or separate trial. If the court decides whether to have separate trial, then my lords, de novo trial, fresh trial will begin only against this person who is added as accused on 319, not against all. So ultimately, my lord, there will be two trials. One against one set of people, the other against the newly added person. Two trials will be there. In the former case, there can be a judgment delivered separately, and in the subsequent case, my lord, because after 319, charges are to be framed against him, evidence is to be recorded. The evidence already recorded in the earlier case is no evidence in this case. Because under 273, you lot may kindly have a look at section 273, my lord.
But please see 3191, it says, could be tried together with the accused.
Who could be tried together,
Ah,
not to be tried, could be tried, who could be tried together, and he may be tried separately also. Language used to be lot may kindly should.
Nagamathu, tell us one situation.
Yes.
Now take a case where before the judgment is pronounced, an application is made either suo moto
Yes.
or at the instance of somebody.
Yes.
Before the pronouncement of the judgment.
Yes.
Now trial is complete.
Yes.
Now what should he do? The magistrate has.
So 319 used to be allowed.
Ah.
On allowing that, he has to pass an order directing separate trial against that person alone.
Now till the trial is completed, the judgment has to await, is it? The other judgment?
Until 319 order is passed, he has to wait for without pronouncing judgment.
No, 319 order not, after a trial on against this person, then simultaneously judgment.
No, not necessary. Because madam, separate evidence, fresh evidence is going to be recorded in the subsequent case.
Yes.
Madam, it is only on analyzing the evidence to be recorded in the fresh case, the new case,
Yes.
judgment can be given.
But in the meantime, can he pronounce this judgment?
Yes, there is no bar.
But then Patwale has no case then.
There can't be. The reason is this, you will not be kindly consider. Madam, there are 10 accused in a given case. 2 people are absconding. Madam, 8 people are tried. The case against 2 people are separately kept. Madam, they are split up, separately kept. Madam, can we wait for the trial of those 2 cases to get completed without pronouncing judgment of first case? First case judgment can be pronounced. The second case will begin later. Trial will go on and there will be separation. But only one thing is, the same judge cannot try. Because he has already made up his mind. He cannot try. The case has to go before some other judge. He will try the case. That's the only thing. So, my humble submission would be, under 223, the court has to decide whether to have a joint trial at that stage. If the court decides not to have a joint trial, there will be a fresh trial against the newly added accused. Insofar as others are concerned, judgment can be pronounced based on that.
Allowed earlier.
Yes, earlier.
It doesn't go against Patwali.
Yes, that is a question.
Application should-
That is why I did not go into that, whether the order was passed before pronouncement or
No,
after.
that is, there is
It should be allowed,
It's a question of fact.
then say that it will be a separate trial and then pronounce the judgment.
319 used to be allowed when the trial is pending. At that stage, when the accused has to be summoned, he will appear. The court has to comply with section 207, supply the copies, and thereafter, court has to frame charge, whether jointly or separately. At that stage, court has to decide. It is only after compliance of 207. All these things must happen when the trial is pending. When the trial is pending, 319 is to be filed. When the trial is pending, 319 is to be allowed. When the trial is pending, accused is to be summoned. When the trial is pending, copy is to be furnished to him under 207. Then at that stage, question of framing charge comes under 223. Under 223, at that stage, court has to decide.
but in this
Court has
case,
to decide whether he should be jointly charged or separately charged. 223.
Muthu, please come at 2. We have to raise a bit early.
Great.
But we may have to ask you a few questions.
Great.
What he's saying actually supports me. He says this order has to be
You are right. You are right. Because the application has to be allowed
first.
first.
Then
Thereafter, he can, because he is right, independent evidence has to be let in so far as that accused is.
thereafter he decides whether he wants to have a joint trial or a separate trial.
Yeah, you are right. You are right.
in this case, but in this case, all that happened on the same date.
Yes, sir. That is
After the judgment was
that is on question of fact, that is to be decided by the other court, not by the Supreme Court.
Nagamuthu, supposing an application is allowed before pronouncement of the judgment, let us
Yes.
assume. then he has the discretion to scrap the entire evidence and try together, or he can independently try this person.
Yes, it is for the judge to decide.
No, he has the option, this or that, depending on the facts of the case.
No, option is for the court, not for the accused.
Yes, this is what.
Court, for the court. Accused cannot demand, Murad, that I should be tried with this man or I should be tried with the other man.
This is what is happening every day. They say, transfer this case from this side.
Cannot make a demand.
Even the CBI says, don't transfer.
No,
this case.
the proviso to 223, it gives a, he can make a request and court may consider even in cases which are not connected.
Yes, accused has to make.
Even the accused can-
a request,
Proviso.
but he can't make a demand.
You can't.
He can only make a request. That is, Murad, in respect of some other case also, he can make a demand. He make a request. Suppose, Murad, I am an accused in 3 theft cases. Only one case is pending before this court. I can request the court, Murad, to bring those 2 cases here to have a joint trial. That is permissible under section 2 to 3. That need not be there. It need not be that all the offences are in the same transaction. 3 different transactions, 3 thefts. Today one, tomorrow one, day after tomorrow. 3 different occurrences. But still they can be tried together. That is dealt with in section 221, Murad.
It should be in 1 year.
221.
It should be in 1 year.
So the accused has got right only to make a request. Please try all together. That is the only request he can make. But it is the discretion of the court whether to allow or not.
We'll come back, huh?
Great. So good.
But you are submitting that at what stage the petition is to be filed and what stage the order is to be made. Sir, I made it very clear in this. That petition is to be filed when the trial is pending. That is until judgment of the acquittal or sentence is imposed. 2, order should also be passed when the trial is pending. The reason is that thereafter, after the order is passed, the accused is to be summoned. He will appear. 207 is to be completed, copies are to be furnished, and thereafter onwards, the court has to decide whether he should be jointly charged along with the existing accused. That occasion comes only at that time. And at that stage, only the court has to decide whether there has to be a joint trial as well. So therefore, all these things should happen not when the already existing accused are still facing the trial, not after that. But the prosecution themselves may at times request the court to have a joint trial. 2 illustrations they can give. Suppose, Mullahs, the newly added accused have given some kind of confession to somebody. That confession, being a co-accused confession, could be used against others, provided there is a joint trial as per Section 30 of the Evidence Act. If the prosecution wants to have the benefit of the judicial confession given by the newly added accused or some extraordinary confession, then they themselves will insist for joint trial. So they can justify the request before the court also. One danger also I would submit. There are 10 accused now facing trial. 2 persons now are added on Section 319. 1 person, after summoning, makes an application to the court that I want to become an approver. He can be made as an approver after giving pardon under Section 307. If he gives a confession, judicial confession with the record on 164, and he is given pardon either under Section 306 or under Section 307. But if it is under 306, under 306 subsection 4, again his statement is to be recorded. That is also an evidence in admissible in evidence. Then, if pardon is given, he will be examined as a witness now in the very same case. If the earlier case is pending, he can very well be examined as an approver in the other case, in which case the others can be convicted based on his evidence, which is corroborated in material particulars by other evidences. So in those circumstances, the prosecution themselves may insist that there has to be a joint trial. If the public case has been already disposed of, where is the occasion to have a joint trial again? Therefore, my humble submission would be that this joint trial business comes only after summoning the accused and after complying with Section 207 CRPC. And it is at that stage court has to decide what to do next. Whether I should join these people with the others and have a trial afresh against all, or I should proceed only against this one separately and proceed against others as it was and give judgment in that at that stage. So therefore, my humble submission would be, Mullah, 319 order should be passed when the trial was still pending. It is my humble submission. But in a given case, in this case, I do not want to go into the facts of the case, whether the impugned order under Section 319 was passed when the trial was pending or after the trial was over is a question of fact. That I am respectfully submitting that question need not be gone into this honorable court at all. At what stage this order was passed? This honorable court has been called upon to declare as to what stage, till what stage this order can be passed. Already it has been declared in Hardeep Singh, till judgment is pronounced. Therefore, my first question can be simple. Yes.
According to Hardeep Singh, does not require any reconsideration. That is right.
Yes, that is my humble submission. Perhaps one more thing. Perhaps now regarding question number 2, the joint trial you said. Then my learned senior counsel was referring to Section 317. That was also pleased to ask me about that. That 317 does not arise at all in this case for consideration. You ought not kindly consider 317 when does it come. It is Section 223 which is relevant. 317, and there is a joint trial. At any stage of an inquiry or trial under this court, If the judge or magistrate is satisfied for reason to be recorded that the personal appearance of the accused before the court is not necessary in the interest of justice, or that the accused person persistently disturb the proceedings in court, the judge or magistrate may, if the accused is represented by the pleader, dispense with his attendance and proceed with the inquiry or trial. Now, this is the power of the court to dispense with the personal appearance.
Like 205, like type 205,
205 is permanent measure.
permanent measure. This is
371 on today,
For the day.
after 10 accused, one is unable
For
to
the-
come. We file petition to 370.
And
It is allowed.
90% of the cases, I think 317 is used.
This is a junior's paradise.
Yes, yes.
For every 370 petition, 10 rupees. Fees to the junior.
Those days.
So in those days, I'm saying,
The common ground is unavoidable circumstances.
yes. In every.
Type is type now.
So, part 2 was relied on by my friend Munir. Part 2, subsection 2. If the accused in any such case is not represented by a pleader, not in this case, he is represented by a pleader, he is very much present. Or if the judge or magistrate considers his personal attendance necessary, which means Munir, he is not present today. We have to read it along with subsection 1. Then, in such an event, there are two options for the court. One, the court may simply adjourn the case, waiting for his presence on the next hearing date, or the court may split up the case. That splitting up will arise only when there is a joint trial. That splitting up is on account of the absence of the accused. That is the reason why it is split up. Now, that question doesn't arise in our case at all. Therefore, I would submit, Munir, in our case, what is the appropriate provision is 223. Where Munir court has been given power. That 223 is an exception to section 218. You ought to kindly have a look at 218 for Munir. You ought to kindly consider this. But 218, for every distinct offence of which any person is accused, there shall be a separate charge, and every such charge shall be tried separately. Now, 223 is in the way, it is an exception to section 218. 223 says that what persons may be jointly tried, then you will also kindly have a look into 219 onwards. 219, 3 offences of same kind within a year may be charged together. 220, trial of more than one offence in the same trial. Then 221 minutes, where it is doubtful what offence has to be tried, alternative charge. 222, when offence proved included in the, that is not relevant for the present minute. Suppose 326 is the charge, the person is convicted in section 324. One cannot say that there was no charge under section 324. Now 222, then 223 minutes, joining several persons in the same trial by having a joint charge. The following person may be charged and tried together. So this occasion, 223 is appropriate provision. Therefore, I submitted Munir, this occasion would arise only when the accused appears. Munir, this will arise only at the stage of framing of charge. When the occasion for framing of charge comes, you will not kindly consider. Now, the 255 onwards, Munir. 225 onwards. Munir, I am referring to the magistrate court warrant procedure, same thing, Munir, therefore I am not referring to that. 225. Munir, 225, in every trial before a court of session, the prosecution shall be conducted by a police prosecutor. 226, opening the case of the prosecution. Then 227, discharge. 228, framing of charge. Munir, it is only at this stage the court has to decide whether there has to be joint discharge and joint trial. This can happen only after the appearance of the accused. That may kindly consider. It may be argued before this honorable court that 319 order can be passed. Accused can be summoned later. By that time, the first trial need not be pending. That kind of alternate argument is also possible. My humble submission would be, Munir, that argument may not hold water. The reason is simple. So, As I gave two illustrations, he may turn as an approved tomorrow. The newly added person may turn an approved tomorrow. In which case, he will be a witness in the first case. Or else, my lords, the confession given in the first case by some accused, judicial confession, may be used against this man. If he is tried jointly, if he tried separately, my lords, that judicial confession given by one of the accused, existing accused, cannot be used against him. Section 30 is a bar. Therefore, my lords, there may be an occasion where, notwithstanding the hardship that all the witnesses are to be recalled, again that we examined, etc., the court may decide to have a joint trial. But in practice, what is happening, my lords, is I have to confess to this honorable court that no separate trial, to my knowledge, is conducted. In every case, my lords, joint trial. And if the lawyer gives a concession, no, you will not recall all the witnesses, you will not recall all the witnesses. These witnesses are sufficient, I will only cross-examine. This concession is given, that is how it is adjusted, but that is totally illegal. In section 273, under 273, evidence record must be recorded in his presence, very present. Because even demeanor of the witness is to be noted down. I should know how the man deposes. Then only I can have an effective cross-examination. It is a fair trial guaranteed in Article 21.
Oh, demeanor will be watched by the advocate. Now, what will this accused do? Sitting in some corner behind.
Suppose the accused is doing the case in person.
Suppose?
The accused himself does the case. He cross-examines. He is not engaging in counsel. There are several such cantankerous people. They do it. So in which case, so demeanor is to be seen. And my mentor used to tell me that out of every 100 rupees that is paid to you, rupees 75 is meant to closely watch the chief examination. Rupees 25 goes for your
Actual
cross-examination.
cross-examination.
Yes.
75 rupees is for what? To decide.
Closely watching the chief examination. Demeanor. Closely watching. So from out of that, we get lot of clues to cross-examine.
Watching.
So therefore, the evidence recorded in his presence is evidence. The evidence recorded in his absence is no evidence at all. Statutory provision is there. 273. CRPC. Your Lord may kindly have a look at 273. Your Lord may kindly pardon me. I'm not taking much time. I'll close it. Yes. Except as otherwise expressly provided. Well, this is under section 317 I read by dispensing with his presence. Except as expressly provided, all evidence taken in the course of trial or other proceeding shall be taken in the presence of the accused. Shall be. Or when his personal attendance is dispensed with in the presence of his pleader. That is not, as my lord was pleased to point out, either 205 or 370. So, it happens for us in some trials. Suppose the accused do not want a trial to happen today. The accused will abscond.
No,
It happens.
that is mostly in the advice of the defense counsel. Someday you know.
It happens.
That your mentor did not tell you. I know that.
Generally,
Yes, sir.
317 application is not allowed when the witness is being examined. Generally, whether it is allowed.
It is allowed, my lord. If it is not allowed, a witness cannot be examined. If 317 is allowed, then personal attendance is accused dispense with, lawyer is present, witness can be examined.
What is the significance of 205?
205, not in someone's case, it is a permanent measure. Petty cases, small, very small cases. Not 205 is not applicable to section cases. Very small cases, from Factory Act case, from Prosecution of Factories Act. So normally they find
Motor Vehicles Act.
small
Company-
cases.
Companies Act
You can even,
Yes.
without the lawyer, you can just.
Companies Act, fine is.
Companies Act, small matters. 205 is paid. And that is not applicable to section cases. Here it is only 317. For every hearing, we have to file petition of 317. So 317 is applicable only during the trial when there is a joint trial. Now, there is a provision, that provision enables the court to split up. What's it? Because he is absent. There is no petition 317. Therefore, at that stage, the court can split up the case and keep this case separately and proceed against the others. That occasion doesn't come in our case at all. Here we are yet to decide whether there is going to be a joint trial or separate trial. That is the discretion of the court. Then, my lords, Shashikant Singh case, it is a two-judge bench judgment that my senior has also referred to. There, my lord, the point which I have been arguing all along, my lord, is reiterated. It is declared that whether it is going to be a joint trial or separate trial is the wisdom of the court. That is held in that judgment, my lord. My lord, this judgment, my lord, has been slightly doubted in the referral order. This judgment, my lord, I have given the list, has been followed, my lord, in at least 10 cases.
Shashikant.
Shashikant has been followed in 10 cases. I have given the list of all the 10 cases. But all two judgments in 10 cases.
But then that view appears to be prima facie correct, because 319
Yes.
of section 1
Yes.
is for arriving at the subjective satisfaction of the court,
Yes.
whether a particular person can be proceeded further with or not.
Yes.
If you read it, where in the course of any inquiry into or trial of an office,
Yes.
it appears from evidence
Yes.
that any person not being the accused
Yes.
has committed any offence
Yes. Yes.
for which such person could be tried together with the accused.
Yes.
The court may proceed against such person for the offence which he appears to have committed.
Could be tried.
Could be. So the subjective satisfaction is whether there is a material
Yes, that is.
that a person to be brought to the court could be tried jointly with other person.
Yes.
And then thereafter, there is nothing which prevents to hold a separate trial against it.
That comes only under
Under 4.
223.
319.
But 319 doesn't say that necessarily the accused is to be tried jointly. It says it could be tried jointly, which means not it can also be he can also be tried separately. But to decide whether there has to be a joint trial or not is the wisdom of the court under 223. Right? That 223 is to be applied not only under when the question of charge framing arises. That will come not only under section 228. Only at that stage, the court is considered whether the accused is to be jointly charged or not. Because 223 says when persons can be jointly charged and tried. That occasion comes only at 228 stage. So until then, the first case is to be kept pending until a decision is taken. That is my humble submission. But so far as Shashikant is concerned, at least in 10 cases I given, in all these 10 cases, Shashikant has been followed and it has been well settled that whether in a given case joint trial or separate trial,
They are also only referred, nothing is said beyond.
yes. Yes, therefore, not in my written submission, I have said, if there is no joint trial, if there is no joint,
According to you, the view that could be tried together is directly not mandatory.
yes,
Is the correct proposal.
yes, it is absolute discretion of the court concern, absolute discretion. Even the accused cannot make a demand. The accused has got no right. It is too well settled. Accused cannot make a demand that I should be tried with the so and so. He has got no right at all. He cannot make a demand. But as it is pointed out by his lordship, he can make a request. Please kindly jointly try me. But it is a discretion of the court to decide ultimately whether to try jointly or not. So he cannot demand. Similarly, the prosecution can also insist for joint trial. Because it will be beneficial for them to prove the charge against some of the accused. As I pointed out, approver, confession, etc. It will be useful for them. So they may also insist, but it is for the court. Taking into account the relative hardship. 100 witnesses have been already examined. We cannot call all those 100 witnesses again in the very same case. Court may take such a decision, in which case the court will order for separate trial. It is for the court. But the law is to be made clear by this honorable bench, Murad. So far as this Hardeep Singh is concerned, this aspect has not been dealt with at all. The third question framed for answering by this honorable court is, what are the guidelines that the competent court must follow while exercising power under section 319 CRPC? This, whether it is to be joint trial or separate trial, may be clarified more on the question number 3. This is my humble submission. But I was said in my written submission, if there is no joint trial, how to go about? If the court decides that there has to be a joint trial, then I have said, if the trial court decides to have a joint trial, then first trial should be conducted against all the accused, including the existing accused. In such an event, the evidence already recorded is no evidence against the added accused in view of section 273, section 32 and 33 of the Evidence Act are not applicable. Section, it may also be argued, section 32 and 33 evidence. That is, prima facie, I can say that it is not at all applicable. On the outset, I can say that. Because
Together may become redundant in a case, for instance, Patwalia agrees. Mr. Patwalia himself agreed that if an order under 319 is passed and thereafter judgment is pronounced in respect of the accused against whom trial is concluded, then this could be tried together become redundant.
yes,
It's not real.
see, particularly we have to wait, because to take a decision whether to have a joint trial or not, you have to wait. Judgment should not be pronounced in the first case. You have to wait, because otherwise this will be detrimental to the prosecution.
No, but you began by saying
Yes.
that suppose there is a 319 order passed, the trial is concluded, judgment not pronounced, 319 order is passed. That 319 order is stayed. If 319 order is stayed, then no judgment can be pronounced in the first.
Yes, for suppose when I
You today morning you said that separately judgment can be pronounced.
no, judgment cannot be pronounced. What I say is not judgment, whether judgment can be pronounced, it can be pronounced, waiting for awaiting the outcome of the decision under 223. You have to wait. Otherwise, this will be detrimental to the prosecution. Because joint trial may be beneficial for the prosecution.
The 319.
Yes.
Then there is no impediment when you pronouncing the judgment.
No, first case, we have to wait for in the first case, the existing case, judgment should not be pronounced. The case, the trial should be kept pending.
Kept pending.
Yes,
But once an order under 319 is passed,
yes.
and if the court doesn't find that a joint trial is necessary,
Well, 319 order is passed in this case, and therefore this case should
No.
be pending.
we are only talking about a proposition.
Proposition only what I am saying,
Oh,
that
so-
in the existing case only, 319 order is part of the existing case.
Yes.
The case should be pending for further proceedings in the very same case. So then only the court, the accused has to appear, his appearance is to be recorded as part of this case. Then copies are to be furnished under 207 in this case only. Then the stage for framing of charge against this man will come later in the very same case. Then at that stage only, it is to be decided whether case is to be tried separately.
Only at that stage,
Yes,
court finds that it is not necessary to try them jointly.
yes.
Only then the
Judgment can be pronounced.
judgment would be pronounced
Yes,
in case of the rest of the case.
yes, Manoj, that is my humble submission. Yes.
So, supposing at the stage before the pronouncement of the judgment, a 319 application is passed.
Yes.
Fine.
Yes.
Now let us assume once 319 application is filed, you can't pronounce the judgment.
Yes.
You decide the application,
Yes.
number one.
Yes,
Let us assume the application is allowed
yes,
and it stood unchallenged.
yes,
then the next stage will be the court has to take a decision as to whether a joint trial has to be conducted or individually it has to be. Suppose it.
In between, Manoj, accused is to summon, accused has to appear, we have to comply with the 207, copies are furnished. So it is possible, provided the first case is pending still.
No. Now supposing the court comes to a conclusion that a joint trial is necessary, as you rightly said, the prosecution may insist. Then whatever has happened to the other accused, main accused, already we will put them as main accused.
Yes.
All that evidence has to be scrapped, is that? Because joint trial means fresh trial along with all the accused.
That evidence cannot be used by the prosecution, it can be used only for the purpose of contradiction, that is
Yes.
scrapped virtually. It is there on record, like 161 statement which we never use as evidence, it cannot be used in evidence. That is all. Though it was recorded as evidence, it has become useless now, except for one purpose, to contradict.
All right, the court comes to a conclusion that joint trial is not necessary. Then that can be pronounced and this case can be independently proceeded.
Yes, Manoj. In that event, that case, the first case will be decided based on the evidence already recorded.
Yes.
So far as the new case is concerned, Manoj, evidence is to be recorded afresh.
Fresh.
All these 100 witnesses are to be examined here in chief. In complaint section 273. In his presence, evidence is to be recorded. That is, suppose, Manoj, let us assume in this way, one person dies.
Yes.
One eyewitness who was examined there, he is the sole eyewitness. He was examined in the first case. He was cross-examined in that case. Now when the second case comes up, he dies. He cannot be examined. Then what to do, Manoj, whether that evidence can be used here?
Yes.
No, under section 33 also it can't be used.
It's gone.
Gone. He is entitled for acquittal in such an
For
event.
his luck, he should die.
Or killed.
No, then you, in fact, you are not, then 319(4)(a),
Yes.
319(4)(a), you are actually making it vocious.
Milord, with respect, Milord, the procedure is in 319(4) after 319(1). Kindly see, Milord, before 4.
4)(a), that's what
One,
I say.
Milord, may kindly see
4)(a),
one line.
Actually, witnesses are examined
Yes.
only against such person.
Yes, Milord, may kindly have one line before 319(4).
Can't be, suppose the whole evidence recorded earlier against the other accused is washed away.
Yes.
Or the 319(4)(a)
Please.
requires evidence to be recorded
Lord, kindly
only
have-
against such person, then there is no evidence against the other accused.
Milord, may kindly have one line before 319(4). I can
It will
read.
happen. Yuratma kindly, practically Yuratma kindly approach.
No, practice. See,
Yes.
the act contemplates this. 319(4)
First line.
actually talks about a case proceeding against a person under subsection.
Yes.
Yes.
So,
Therefore, where the court proceeds against any person under subsection 1,
Yes.
under subsection 1 presupposes where the court comes to the conclusion that they could be tried together. Even in such a case, the proceedings in respect of such person shall be commenced against such person, in respect of such person shall be commenced afresh and witnesses be heard. To say that once 319 is allowed, all 100 witnesses will be recalled, fine. But they will be examined only
recalled,
in so far,
examined afresh.
examined afresh, only in so far as the role relating to the 319 accused, not in relation to the role against the other accused. That can't be the
No, it is not possible practically, I say.
practical.
Practically, I say. But there can't be two sets of evidence in a given case. One set of
No, it is one composite evidence. That is why the evidence recorded earlier and the evidence recorded later. It is like recalling and
No, put the court, while delivering judgment, put the court, rely on the 100 witnesses already examined.
no, it is like recalling. That's all. 311. Suppose 311 had been allowed.
No, it can't be recalled because the reason is those witnesses cannot be recalled by the newly added accused for the cross-examination. That is my humble opinion. Reason is this.
But it is, once you say, the moment a 319 order is passed,
Yes.
the whole thing is thrown open even for the other accused.
Yes.
Will be a very, very abhorring proposition because then no trial can. See,
No, that is the reason why I say there is alternative. If this will result in so much of hardship, have a separate trial.
Separate trial.
Separate trial.
Pronounce the judgment on in respect of others.
Yes.
yes.
Yeah, otherwise that will happen. You have to kindly see.
Once it is accepted that there can be a separate trial,
Yes.
there is no necessity for 319(4)(a) to say against such person.
Yes.
And with reference to subsection 1. This
Not,
is
not,
actually with
not,
reference
this
to
can't be interpreted in such a way, Milord. You not may kindly consider this. There are 100 witnesses already examined. This accused, newly added accused is not going to cross-examine them because it is no evidence so far as he is concerned. 273 is a bar. Now, some more witnesses are examined against him. Now, what will happen? There will be ultimately two sets of evidences. One set of evidence against already existing accused, one set of evidence against the present accused. Is it contemplated CRPC? No, it can't be. Therefore, my lord, the evidence should be common against all the accused. My lord, if there is joint trial, the evidence should be common. My lord, suppose one answer is elicited during cross-examination by one accused. Can we say, no, that was elicited by him, therefore it is not binding on me? No, it is evidence.
No, that becomes a matter of appreciation.
No,
Can't
there-
say that the whole.
Because appreciation cannot be taken read in isolation from the evidence. Because the evidence is to be one and the same. Because the evidence recorded in a case is common against all. There can't be one set of evidence against one set of people and another set of evidence against other people. Because 311 is not applicable.
Suppose each man has got a role.
Cognizance of the offence upon which the inquiry or trial was commenced.
So that is because of the same transaction. See, he is found to be, see what is inferred into.
I'm actually one with what your lordship is saying here. In fact, I have a slightly different path here. I agree with what is falling from your
In
lordship.
fact, 319,
No,
by the
let
NY.
me let a friend explain to me, Mullah. No, I want to know it. No, please, let us understand what the law is. Let's, in a given case, 100 witnesses have already been examined. Now, no more witness is going to be examined now. No more witness. Can you use that evidence against me? No, you can't use.
No,
Then how will you convict me?
no, it is not used against you. That is the reason why, in so far as you, again, in respect of such person, according to you, has got no meaning.
No, it was some interpretation. Not interpretation used to be workable. My humble submission is, 100 witnesses have already spoken. All are exhausted.
Correct.
No more witness.
You are right.
No more witness.
Is a-
Now, what can I do? I am the newly added accused.
If the words could be tried together could be interpreted to mean that is only directory and not mandatory, then we will have to apply an interpretation to clause A of subsection 4, so that there is the whole thing gives a comprehensive meaning.
Let me try to understand, brother. 100 witnesses have been already examined, all exhausted. No more witness. Now I am added as accused. How to go about in respect of recording evidence now?
So for his role, you examine.
For me, as against me.
That's all.
As against me, already witnesses have spoken that the reason why I have been summoned under 319, now that evidence is no evidence against me. Now trial has to afresh go.
That evidence is no evidence against you because they were not examined in your presence.
Yes.
Now they have to be examined in your presence.
Yes.
You get an opportunity.
How to examine?
If
Chief
what you
class.
say is accepted,
Chief examiner.
all other accused also will again have an opportunity to cross-examine. The whole thing is completely thrown open.
But cross-examination will not close anything. Cross-examination is the right at any number of times one can have opportunity to cross-examine. But my humble, this predicament you ask me kindly consider. But I come to the court, I say, all witnesses have been examined in my absence. There is joint trial. What shall I do now? You can't use that evidence against me. I do not want to recall any witness. You can't use that evidence against me. Then I am entitled for acquittal. The whole exercise under 390 will go waste. Therefore, my lords, it is to be interpreted to say that when you decide to have a joint trial, there has to be one single trial. There can't be two trials, there can't be two sets of evidence.
No, it is a single trial where witnesses are again examined, that's all. It is not that it is a single trial,
In
that's not.
the illustration,
single trial is not lost.
in the illustration which I gave, where is the question of examining again? But may I ask the question to myself, 100 witnesses already exhausted. I am not recalling any witness, I stand.
Prosecution
What is the question of
can call
exam?
witness, there's not need, prosecution will require witness because prosecution has to prove its case.
Yes, 311.
No, see, when there is a separate trial, are concerned, already record evidence may be sufficient. But we have to ease down the situation of trial courts. We cannot make the provisions very hard for them to follow by interpreting. So this is the only way we have to make the things very easy and workable for the trial courts. If there is joint trial, see, that is the reason why we are going to tell the court, don't have joint trial. Because 100 witnesses have been examined. This will be an unnecessary hardship. That is why I submitted already. The other accused have already cross-examined 100 witnesses. Now we are not asking them to again cross-examine these 100 witnesses. It will be an unnecessary hardship. It will not be fair. It's not a fair trial. This is a ground to have a separate trial. This is a ground. This will cause unnecessary hardship. 100 witnesses have been examined.
And who knows, they may have included some admissions in the cross-examination. Everything will be blown away.
Yes. Yes. Therefore,
Best thing is to
Have a separate trial.
separate trial.
suppose the witness now turns hostile. So what can we do for that?
Can't help.
The witness now turns hostile in the second trial. So the witness on whose evidence 319 was ordered now turns hostile in the first trial. We can't help. That is what is the conviction rate that we are recording in this country? 7-8%.
5%.
5%. There is murder. He has not committed suicide. Man died because somebody killed him. Who is that somebody? What is the system? We say that the prosecution has not.
Anyway, still they are punished, Nagamatu,
Yes.
for the simple reason. Process itself is punishment now in our country.
But it is
They are
extra.
still punished. They may be acquitted ultimately, but they would have suffered, for 10-15 years.
This is extra constitutional punishment. IPC doesn't say that this is a punishment.
Exactly.
Practically, there are a lot of. The last point that I fully agree with Mr. Chakwadia. He said, Manoj, that in the given case, 319 petitions were separated from the main case. It was treated as an independent case. There was an order passed. But that, in my humble submission would be, this is wrong. Well, this should be part of the main case as a submitted. Order is to be passed in that case as an interim order. Then, in that case only copies are to be furnished. In that case only, decision is to be taken whether there is to be joint trial or not. But if it is an independent proceeding, then the evidence in another case, that becomes an extra case now. It's another case. That cannot be considered. So that itself is wrong. It is my humble submission. The trial court ought not to have separated the 390 proceeding as a separate proceeding and decided as an independent proceeding. That is not correct, Murad. I also said in my.
But Nagamatu, see, on the main SC, they call it sessions case.
Yes.
It's disposed of. Then how do you continue with the same number, session case two?
Not-
Something like cricketers, so two, some.
That is why essay merit should not be disposed of.
Something like that.
Well, that is why essay merit should not be disposed of. It should be a sessions case. But this should be a miscellaneous application in the sessions case,
Okay.
part of the same proceeding. It cannot be a separate proceeding. It can't be an independent proceeding. But in this case, Murad, from what it was,
Yes, yes, that's.
they are separated. That is wrong. So far, a third proceeding is
That's a
concerned.
query which my lords have put, my lord. They are separate session cases in the same FIR. In case the accuser absconding and subsequent charge sheet is filed, you have sessions case maybe 5 in the first one and maybe 20 in the second one. That is the practice which is being followed. It need not be the same sessions case. So if supposing there are 10
It need not be. Here also where for the other separated accused,
yes,
there is a separate sessions number.
yes.
But so far as this application is concerned, is not in that sessions case number, it is in this
It's a
session.
miscellaneous. It is a
That is where
miscellaneous-
the difference
It's a
is.
miscellaneous thing.
Well,
But
when
as
the
far as
accused
trial
will
is
appear,
concerned,
when
there
the
can be
accused will
two
appear,
sessions
well, then the number will
Maybe, maybe while trying separately, maybe if, then that miscellaneous case may be a fresh number, such
Yes.
as case may not be.
Please.
Purpose of deciding the 319
Yes.
application, nothing to do with the sessions case. It's only for the purpose of deciding the 319 application that a separate number is given.
No, that miscellaneous should be in a sessions.
Yes.
It may be, but.
It is
but
separately
but
not kept.
Like
And then-
supposing,
You
Bail
have
application.
a miscellaneous case, decide and then say now this becomes sessions. In a sessions
My lord is
case, the
right.
miscellaneous application.
Originally, the application
like
was in
getting
that
custody of goods, for custody of goods, you have a separate application. But it is in the same case, but the application is separate, it has nothing to do with the main trial. When you apply either in 451, 452 or 457 for getting custody of goods, the application is numbered separately.
No, no, that is because there is no right to the accused there. You just get back your things.
Yes, but you have to apply in
You
that
get back
case. You are
your
applying in the
things from
case
the court.
that is not, it is not part of the session case, it is a part of a miscellaneous application which is made.
If it is a miscellaneous application, in A case, you can consider the evidence in A case. If it is a miscellaneous application B case, you can consider the evidence in B case. If it is neither in A case nor in B case, what is the evidence that you are going to consider?
The proof of the pudding is in the
What is
eating.
the evidence?
Till 31st, the application is marked in that session trial. All orders are on the record.
But it was separated.
It is only after 31st that it becomes sort of orphan.
Evidence of the
Because-
sessions case has to be considered.
28(9)
That's all about
Yes, after, until
28(9).
it is mentioned in that section trial. Then after 28th, it just becomes orphan from that trial, which is not possible.
But it could have been considered before the judgment was rendered in this case.
Can-
This application could have been considered and a separate trial could have been ordered also.
Correct.
Yes.
Now, the whole only thing is it has been considered after the first case has been disposed of.
Correct. That's the-
If this application treated as part of the second case, then evidence is to be recorded. In that case, then only decision can be taken. Now there is no evidence in the case. Evidence is only in a case. So this should form part of this case. It's a miscellaneous application.
No, but the trial could have been separated also.
Yes. Then only the occasion being occasion to decide that there will be joint trial, etc., will come.
Yes, Nagam.
So lastly, my friend was referring to Jogendra Yadav, State of Bihar. That is the case, I do not know whether it will be appropriate to raise that issue in this case. That was a case where this one of the two judgments stated that before invoking section 319, before passing an order, you have to afford opportunity to the accused, proposed accused. He has to appear, he has to say that there is no evidence against me and there is no justification to pass an order under 319, then only when an order can be passed. The judgment also further say, on his appearance, copies will be furnished and he is not entitled for discharge. That judgment. I got my own reservation about that judgment. And I raised it, his lordship left it open to be raised in some other case. And before the two judgments I raised it, his lordship left it open to be decided in some other case. So that is also that Jogendra Yadav also will not make
That judgment may not be relevant here.
Anyway,
May not be relevant.
reference was made by my friend
Anyway, that may not be relevant for us.
I am very grateful for having 12 minutes wonderful opportunity.
Thank you. So
Grateful to all of you.
just, I think one of you, somebody, you wanted to make brief, very brief. Very brief. Very brief.
Just
5 minutes, 5 minutes.
Lordship, please have a look at the notes.
5 minutes. Which case you are in?
Lord, it is Devendra Kumar versus State of.
There is separate case.
Yes, it's a
Referred
separate
matter.
item. Yes, Lord, referred.
All right. tell
Your
us.
Lordship, it doesn't mind, Lord, take up the paper book of 6960 only for small purpose. Your Lordship has the note, Lord. Just quickly given snapshot of the fact, one fact.
But question is same, no? Question is
Question
same.
is simple. If your Lordship sees, Lord, item 4, 21 March 2012, Lord, the trial court passes a judgment convicting all accused persons in a pre-lunch session on an event date. Thereafter, on the same date, after the lunch session, pronounces the judgment and sentences the accused. And Lords, after that, by the separate order of the event date, summons the petitioner.
No, this is not disputed, is it?
There is no dispute, nothing disputed by the state to that extent. And it is, my Lords, placed in the paper book, page 70.
This is state of UP.
Page 70 of my paper book, my Lords, I have placed, if your Lordship doesn't mind, my Lords, page 70 of the paper book would show exactly the sequence in which it is, my Lords, placed. The judgment with respect to
Session, the judgment was pronounced. Thereafter, what happened?
Lords, after the lunch session, the sentencing is done for the other accused who are convicted.
All right. Then
Thereafter, by the separate order at page 70, Lords, I have been summoned as a petitioner here.
This was after tea.
After. So, Lords, I am summoned at that stage. So clearly,
he got ideas after the
probably, Lords. And Lords, I have also placed the actual photocopy of the judgment, which, Lords, not just the translated copy in English, which is at page 90, which will show actual pronouncement first pre-lunch, sentencing post-lunch, then a separate order. Though the order does not say whether it is passed under 319 or otherwise. But assumingly it is passed under 319.
It is referable to 319.
Yes.
All right.
So that is the facts.
Because actual provision need not be quoted.
That's right. So it is, my Lord, referring to 319. And my Lord, with great respect, your Lordship have already seen 319 few times by now. If I may just place it once more, my Lord. 319, my Lord, relates in the initial portion where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person could be tried together with the accused the court may proceed against such person for the offence which he appears to have committed. Lord, the words used would be the stage is determined during the course of trial. Lord, whether this provision is to be read, the trial concludes with pronouncement of judgment or prior is what your lordship should not decide. Hardeep Singh says at two places, para 40, it says it can be done till conclusion of trial. If your lordship doesn't mind, my note I have extracted para 40.
Conclusion of trial means actual pronouncement of judgment.
At para 40, Hardeep Singh says it can be done up till conclusion of trial. At para 47, it says before pronouncement of trial. I say this, my lord, because the usage in the code are also at some places used differently. So certain places the code uses a terms conclusion of trial. At some places code uses the term before pronouncement of judgment. At some places the code uses the term termination of trial.
But what is the language?
Here, your lordship,
CRP.
I'm saying, my lord, within the CRP, at certain sections the language uses conclusion of trial.
And in this particular chapter, Nagamuthu showed us some provision.
But Lord, I placed the chart. It has all the provisions. You Lord,
Provision.
Lord, I
The conclusion of the trial comes to an end only on pronouncement.
there is no provision in the code.
Ram
Lord, which
Narang,
says-
Ram Narang, Ram Narang, Ram Narang.
Ramnaran.
Narang.
Lord, the
That
term,
judgment is very clear.
that judgment says termination of trial, not conclusion of trial. Your lordship sees, my lords, the chart I have placed before your lordships. At page 2, my submission is, my lords, any word used within the code has to be given its natural meaning. It is not superfluous. And if your lordship sees my chart, my lords, at page 5 onwards of the note that I have placed before your lordship, where different phrases within the code are used, my lords, interchangeably or not, is something your lordship have to see, my lord.
Language employed in the judgment is not a statute.
Yes, my lord. So therefore, your lordships are
In the context, perhaps you have to understand in the context.
Your lordship 319 in any case is circumscribed by a stage. It cannot be beyond the trial. It has to be during the course of trial. Hardeep Singh says clearly it can be done till conclusion of trial at para 40, and it says at para 47 it can be done before pronouncement of judgment.
According to you, when does trial come to an end?
But according to me, for the purpose of 319, the court cannot go beyond the conclusion and reserving of judgment.
No, Nagamuthu said, even the judgment, the matter may be reserved for judgment. Thereafter, the court may suo motu reopen. What happens then?
My lord, in that situation,
Therefore, I think the interpretation in Ram Nayaran appears to be correct. In the sense, once it is pronounced, then only the trial comes to an end.
terms are termination of trial will be right. Your lordship would be right in holding that with pronouncement of judgment and
It
sentencing.
is against you. Why are you arguing?
No, my lord. I am placing before your lordship what means by conclusion of trial. If your lordship sees page 5, my lord, I've just placed couple of things.
Ram Narayan.
I'll look at Ram Narayan also alongside.
Ram Narang,
Ram
Yes.
Narayan.
Ram Narang.
There is no
person accused of an offence and person accused of abatement or attempt to commit such offence. Therefore, my lords, could be tried together will relate to 223 for the purposes of the court to see who can be accused. And my lords, now if your lordship sees 3192, where such person is not attending the court, he may be arrested or summoned as the circumstances of the case may require for purpose aforesaid. Any person attending the court, although not under arrest or upon summons, may be detained by such court for purpose of inquiry into or trial of the offence which appears to have been committed. Lords, 3194 is very important. Where the court proceeds against any person under subsection 1, then the proceeding in respect of such person shall be commenced afresh and the witnesses reheard. Lord, with great respect, in this situation, the court will be, Lord, determining the same trial as against the earlier accused. Within that same trial, my lords, it contemplates the proceeding in respect of such person shall be commenced afresh and witnesses reheard. My lords, as so far as the person being impleaded or summoned now is concerned, qua him, whatever witnesses have deposed which relate to any imputation, allegation qua this, Lords, all those witnesses are contemplated to be reheard within the same trial. And Lords, nowhere within this 319 there is any concept of considering or fixing a separate trial, is my humble submission. If your Lordship sees 4 with me, Lords, where the court proceeds against any person under subsection 1, then the proceedings in respect of such person shall be commenced afresh and the witnesses reheard. B, my lord, says, subject to the provisions of clause A above, the case may proceed as if such person had been an accused person when the court took cognizance of the offence upon which the inquiry or trial was commenced. Lords, 319 subsection 4 B, Lords, clarifies it cannot be a separate trial. It is with respect to such person within the same trial that he has to be, my lords, and obviously so. Your lordship saw 273, which says no evidence can be, my lords, taken without the accused. Now I am being, my lords, made an accused under 319. When I am being impleaded or summoned as an accused, there cannot be any evidence that can be read against me in my absence. Therefore, it contemplates it is to be done afresh and witnesses reheard. Otherwise, my lords, I can be, my lords, made to suffer the guilt.
Assuming you said the judgment was pronounced in the forenoon. Now, let us assume 319 application was allowed in the forenoon and judgment was pronounced in the afternoon session. What would happen? What should happen?
My lord, in my respectful
Are
submission,
you saying that then, unless there is a joint trial, no separate trial is permitted?
no, it is not permitted.
This
That
is
is my
your submission.
That is my submission, my lord, with great respect. That is my submission because the court is trying the offence, not the offenders. And the cognizance is that of the offence. So the trial is for the finding the guilt, who is the offender, qua the offence. Await. If your lordship, the judgment with respect to other accused is pronounced, evidence read, dealt with, bound to be against the other offenders and the offence having been committed, I am gravely prejudiced.
No. Independent evidence will be recorded so far as you are concerned.
But my lord, that is not, therefore 319 doesn't permit a separate trial, is my submission. 319 nowhere provides for a de novo trial or a separate trial. It says within the same proceedings. What is relating back is, my lords, the proceedings. The cognizance is that of the offence. And 207, 208
So
state,
why can't cognizance for you cannot be taken?
because the court provides for the court taking cognizance for the offence. And then the investigation and then the evidence for the offenders. So therefore the trial is of the offence.
All right. Any other subject?
And this is only on the basis of the evidence that emerged.
Yes, and my lords, it cannot be so that there is a evidence brought on record for 4 accused and judgment pronounced, which is unchallenged. Then I am being made to suffer a separate trial. Where is my windows to defend myself, my lord, with all fairness?
No, on the other hand also,
It is not available to.
My lord, then there is no other evidence.
They'll have to read afresh is what is said.
But my lord, then there is no other evidence. There is no challan before a separate court. Where is the provision within the court providing that record goes to the separate trial?
no, there can be a converse situation where the first few accused are ultimately acquitted and the person summoned is convicted.
It can be, my lord.
That could also be there.
So then I go scot-free. It would not be the case because
Because the first few may have been wrongly, produced and arrested and summoned them.
Notice 319, as read by the Constitution Bench judgment in Hardeep Singh, relates to that if there is a person who is guilty of an offence, should not go scot-free. That is the premise of 319.
Yes.
But my lord, there is a circumscribed within the provision as to when you can exercise that power. Because your lordship, at the same time, the rights of the accused to defend himself in all and to defend in a fair manner is also.
Are you saying Hardeep Singh is not correctly decided?
My lord, I am saying Hardeep Singh is correctly decided. It says conclusion of trial and the trial conclude with reserving the judge.
Harping upon para 40.
40. And termination of trial is with sentence. Conclusion of trial is with the argument being reserved, judgment reserved.
No, even there you may not be correct because 353 uses the word immediately after termination of trial or at any subsequent date, which means termination of the trial is one day in the timeline. Termination of trial is one, delivery of judgment is another. Otherwise, at any subsequent time means subsequent to the termination of the trial.
My lord, 353 with great respect, my lord, says immediately after.
Or at any subsequent.
So therefore, it is the mandate on the concerned court to not delay the pronouncement is what I read.
No, you are reading it to mean termination of trial happens with the delivery of the judgment. Correct?
My lord,
That's what you said.
I am saying conclusion of trial,
No, no, that's
pronouncement
not-
of judgment and termination of trial are 3 separate concepts within the court.
No, but you said sometime before that closing of the trial is different. It comes with before the judgment is delivered.
Yes.
Termination of trial happens with the delivery of the judgment is what you said before.
With the sentencing, lord. What was played by my
That may not-
was
Three shows that termination can be at a milestone before the delivery of the judgment. Correct?
Can I read, my lord, 353 with your lordship?
Yes, immediately after the termination of the trial or at some subsequent time. Or at some subsequent time means the termination of trial is one milestone. The pronouncement of the judgment can be at another milestone. But you earlier said termination happens only when the sentence is complete. It need not be. Sentence can be.
My lord, I may stand corrected to that extent.
Yes.
I can stand corrected. But my lord, the import of 319 together is during the course of trial, which exercise is in any case prior to delivery of the judgment, as also read from 353 or also read from 3194. 3194, my lords, relates to any person who comes into picture after 319 exercise of powers is to be, my lords, tried fairly. No evidence which is taken in his absence should be read against him, as my lords contemplated in 273. Therefore, it says witnesses reheard. and proceedings in Lords 3194B relates back to 207 and 208. And those will be encompassed within the same trial, and therefore the pronouncement of judgment for the other accused has to await, is my respectful submission before your lordship. And my lord, please see the languages used, not just for my page 5 of the note as used in the code. At some places used differently, my lord. 5 not B, when in relation to the same subject matter, page 5, B, wherein where in relation to the same subject matter, different words are used in the same statute, there is a presumption that they are not used in the same sense. We have kind of not culled out not what provisions or phrases are used. If your lordship sees phrase A, it says conclusion of trial. On my first column, you're not seeing. And the respective provision is 209. If your lordship turns over 209B, Lord uses the term subject to the provision of this court relating to bail, remand the custody to accused during and until the conclusion of the trial. And if your lordship sees Lord 357A with respect to victim compensation also uses the term at the conclusion of the trial. And Lord 437(7) is interesting. Lord, it is Lord with respect to when bail may be taken in case of non-bailable offence, if at any time after the conclusion of the trial of a person accused of non-bailable offence and before judgment is delivered. So, my lord, there are two different stages within the Lord's code, is what my respectful submission is, as contemplated by reading of different uses and different phrases within the code. So, after conclusion of the trial and before judgment is delivered. So pronouncement of judgment, my lord, may be a stage later than conclusion of trial, if you read your lordship in this respect. Similarly, my lord, 437A, where bail required accused to appear before the next appellate court before conclusion of trial is the usage, my lord. And 451, at your lordship sees page 7 overly, which is with respect to order for custody and disposal of property pending trial in certain cases. When any property is produced before any criminal court during any inquiry or trial is same as 319, the court may make such order as it thinks fit for proper custody of such property pending the conclusion of the inquiry or trial. And 452, my lord, uses the word order for disposal of property at conclusion of trials. So there is a difference of usage. If your lordship turns over at page 8, the words used are judgment is pronounced. Your lordship has page 8, phrase B on top column. Lord, judgment is pronounced as the usage in certain provisions. For instance, 216, Lord.
Concluded. No, that is depending on what is the requirement. Here, disposal of property and therefore the judgment. The other one is bail, to be released on bail, therefore trial and judgment. So depending on the requirement, the use of the terminology.
Therefore, my lord, the
Therefore, you can't,
interpretation of 319, my lord, will have to
can't
be,
import that to this.
Lord, therefore the
So what is the
interpretation
purpose
of
here is the question.
purpose 319 has to be read, my lords, in a manner which circumscribes the stage beyond which it is not exercised.
So if you understood correctly, according to you, if 319 is allowed, either joint trial or no trial, that's all. This is what you want to suggest.
So there is only one way, joint trial. There is no trial. If there is someone, then there is one trial.
All
My lords, you heard.
Or
Lord,
anything else,
Just give me
anything
a
else.
few more minutes. I'll finish, my lord, in 3-4
We
minutes.
gave you only 2 minutes. See, now it.
Lord, why I want to emphasize on this? Because, Lord, there has been adequate opportunity for the court to do this exercise so far. Therefore, it is not required to do it at the stage of pronouncement of judgment. Please see, my lord, the scheme of the trial. Page 9, my lord. The scheme of trial before a court of session is, my lord, briefly called out for your lordships. Page 9, bottom it starts, and page 10 I am here. It starts with, my lord, opening case for the prosecution. If your lordship has page 10 of my note. And then, my lords, the stage is at discharge at 227. Lord, this is one stage where the court has evidence under 319 as contemplated, which is post challan during inquiry. So there is evidence before the court. And at this stage of discharge, the court is perusing and sieving through the evidence. The court has the opportunity to exercise 319 at this stage also within the contours of 319. If your lordship, my lords, just moves forward, my lord, next is framing of charge. Then, my lords, your lordships were pointed out the order of acquittal, which is order which your lordship mentioned is not exercised for certain decades. If the prosecution fails to bring on record adequate evidence, there can be an order of acquittal. So there is a stage within the scheme of trial. The court has to look at and exercise and sieve through the evidence. If there is no adequate prosecution evidence, then order of acquittal can be passed. So the court is exercising its judicial mind over the evidence before it.
What is the point that you're putting forward?
Point is not, there is adequate stages within which the court is exercising and looking at the application of mind with the evidence available. So therefore, having failed during this time period, there is no occasion within the court to summon the additional accused.
The additional accused at what stage?
At the stage where the application of judicial mind will not rest with the conclusion of arguments, there are 3 occasions. One was not at discharge, second at acquittal, and then, my lord, at the stage of judgment. The judgment, my lord, is set out 2 places in the court. At 232, your lordship will see.
No, 232 is an order of
Order.
acquittal.
235. 235 is also judgment. Within the scheme, my lords.
Judgment of execution.
So, my lord, 234 is the arguments. This is the third stage, my lord, where the court has adequate opportunity to look at the evidence before it. At the stage of arguments, at 234. And then, my lord, 235, after hearing arguments and points of law, if any, the judge shall give a judgment in the case. If the accused is convicted, the judge shall, unless he proceed in accordance with the provision of 360, hear the accused on the question of sentence. And my lords, then 235 will be, my lords, read with the way it is to be pronounced, as my lord set out in 353. 353 again, my lords, titles as judgment within the court. And my lord, 353 contemplates the judgment in every trial in any criminal court or original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of the trial.
That we already read it.
Yes, my lord. So, at all these stages, my lord, till arguments of 234, the court and 235 judgment is pronounced for acquittal or conviction. The court has had a look at the evidence before it. Therefore, 319 does not contemplate a situation where beyond that stage, court is to, my lords, summon an additional accused, is my respectful submission. And, my lord, there are two small judgments, two high court judgments in that sense, my lord, which deal with 353.
Now let it pass on that.
And I have not spelled out all those two judgments paras in the note for your lordship. Lords, just couple of other submissions. 311 was being, lords, posted before your lordship, where lord, my senior colleague was mentioning that you can do it at any stage. Lords, the language used in 311 is completely contrast to what is used in 319. Lords, 311, power to summon material witness, examine, present. It does not relate to accused. Number one. It clearly says any court may at any stage of any inquiry, your lordship has 311, trial, any court may at any stage of any inquiry, trial or other proceedings under this code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall or examine any such person if evidence appears to be essential to the just decision of the case. It does not relate to the accused at all. But we are talking about 319 where there is somebody being now made to face a trial in a criminal case. So, my lord, your lordship will exercise, my lord, the interpretation of 319 in a restrictive manner. Having, my lord, looked at the scheme of the court. I'm grateful.
Yes.
Please go on. Well, it's a clear and great opportunity, my lord, to assist the Honorable Court. And irrespective of side I am representing, my lord, I'll try to assist on the law. My lord, before saying, my lord, Mr. Patwalia had argued about that judgment, my lord, I've got the judgment. He can be up and down, but it is only one page, my lord, different. It is page 282 instead of 283. The judgment is there. I'll not pass on the judgment, which is referred to in the order, although that is not relevant. Just, my lord, to saying that 282 was written there, it's 283 page. That judgment, my lord, which was referred to in the order. Now, my lord, may kindly have typographical error, my lord, only of one page. Probably they had leap of 10 pages, my lord. It should have been one page either side.
It's not at all relevant. It doesn't say what the.
I'll pass on the judgment also. Anyway, I don't dispute because that is not. I'll pass on the judgment. Para 7. Para 7.
Yes.
Now, my lord, I'll try to restrict on the reference only, my lord. Reference before this.
Do it on my turn. I've seen.
Lord, the references, my lord, 2 points. They are important points. Reference, my lord. I'll read the reference order, although, my lord, it has been read earlier also. One, my lord, whether the trial court has the power under section 319 CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. So, my lord, the first point is whether on the day, my lord, when the judgment is pronounced, thereafter, if the summoning order is passed, whether it is correct in law, that is the first. Second, my lord, the question framed is whether the trial court has the power under section 319 CRPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing pending, having been bifurcated from the main trial. So, my lord, that will be whether when the accused whose trial has been separated, bifurcated, whether an application under 319 moved in that case can be considered to be legal. That is, my lord, second point. So, my lord, as far as the first is concerned, well, may kindly have 319. Although, my lord, 319 has been read earlier also, my lord, I'll also take opportunity of reading 319(1) again. Because, my lord, it will be in the seriatim wise as to how 319 has been framed. Kindly have one, my lord, 319(1). Where in the course, my lord, course is important. I'll refer to course, my lord. Where in the course of any inquiry into or trial of, well, there's a comma, inquiry into comma or trial of comma, an offense. So inquiry into an offense or trial of offense. So well, these are two things. It appears from the evidence that any person not being the accused, who is not accused before the court, has committed any offense for which such person could be tried together with the accused, the court may proceed against such person for the offense which he appears to have committed. Now, 319(1) is to identify the person as to who is the person who can be tried. It is not the procedure which is mentioned in 319(1). It is only to identify that a person who seems to have committed the offense can be tried with the other accused who are being tried by the trial court. So it is not here procedure established or procedure said that a person who will be summoned under 319 will be tried along with the other. Kindly appreciate again, 319(1). I'll read 319(4) again thereafter. Where in the course of any inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused, the court may proceed against such person for the offense. Now, the court finds which person, identifies, yes, the FIR is the same, the offense committed is the same, and he seems to have committed the offense for which the other persons are being tried. He can also be tried for that offense. So this 319(1) is for identifying only. Now, thereafter, the scheme of the section is, the procedure is established as to how that person who is summoned under 319 or court comes to a conclusion that this person can be or could be tried with the other accused. Now 319(4). Now 319(4), first line is very important. This is what I said, where the court proceeds against the person under subsection 1. So the court has proceeded under subsection 1. The court has formed an opinion that this person could be tried with the other because he seems to have committed the offense which the other accused have committed. So he has summoned, the court has summoned. Then the procedure is, the proceedings in respect of such person shall be commenced afresh and witnesses reheard. So the procedure established is, when the court summons that person as accused, then how the trial will proceed. The section says, then the proceedings will respect of such person shall be commenced afresh from the very first instance as the other accused. And then the witnesses will be reheard. So as far as this man is concerned, it will be de novo trial. The proceedings will start again. The witnesses will be reheard. Now, So, that there can be a de novo trial and should be de novo trial for a person who is identified later on. And one thing more, I'll refer to this course and other things also. This provision is for the court. Kindly appreciate, we can say the complainant is biased. We can say investigating agency is biased, but the court is not. This provision is for the court to identify. Now, the court identifies a person and comes to the conclusion that this person might have or seems to have committed also an offense, which the other persons for who are being tried can be summoned. So, it's before a court. That is what the judgment says. 319 is a provision given to the court.
So it's like a deemed cognizance.
Yes, Milord. And for the court, Milord, kindly appreciate. I can say, Milord, as a state, I may be biased. As a complainant, as accused, somebody can be biased. Here's a court. Court goes through the evidence which is before it, goes through the witness, and then Milord forms an opinion. Yes, 319(1). This person can be summoned and tried along with them. Opinion that could be tried. It is not an opinion that it has to be, this man has to be tried along with the other. So 319(4) says that the procedure will be the same, evidence already taken will be the same, and the trial will proceed de novo. The witnesses will be, because 273, he was not present when the witnesses were examined. So the witnesses, and one thing more, the witnesses in earlier trial may give some other evidence. Witnesses in the present case will give some other evidence. They may have resigned. They might not reside in the present case. So the appreciation of evidence, one of the arguments raised was it will prejudice the case. It will not, because that can't be taken into account as far as this case is concerned. The evidence recorded in the present case will be taken into account by the court on coming to the conclusion whether he has committed the offense or not. So my submission will be, it will be a de novo trial starting from the stage, first stage as the other accused are concerned, and all the witnesses will be reheard.
Please clarify one situation.
Please, Lord.
Are you suggesting that there will be only a de novo trial only insofar as this particular accused concerned? Or are you saying that even joint trial is also possible?
Well, I say both are possible. The court can try at the joint also, because most of the cases, although the reference
In a case the arguments are concluded, matter is reserved for
yes,
judgment.
the court will come to the finding. Now, what has happened?
No, in such a situation, are you suggesting that joint trial is still possible, or
the discretion, with respect, the discretion is left to the court. If court finds that it's a case where it should be tried separately, the court will separate the trial and it will be tried separately. Where my lords have given an example where the trial has concluded almost and the judgment is pronounced, court may say this trial is separated. But in some cases, most of the cases, it's only after one witness is examined that they are summoned. Most of the cases. It is first PW when complainant is examined and they are summoned under 319. I will say more than 90% of the cases in which only one witness is examined, complainant sticks to his version. I'll give one example. Now complainant says A is accused. The investigating agency finds B and C as accused. The challan is presented against B and C. The complainant comes in the court, say no, B has committed the offense. Now, to say that the court doesn't have power to summon even at the stage of pronouncement of judgment will be travesty of justice.
No, they are not saying at the stage of pronouncement of the judgment.
They
are saying after the pronouncement.
I will come to that also, but I am only on the fact of, I will argue that also, but I am only on the point as to whether they can be jointly tried. Well, I am only trying, I agree with the learned senior counsel that it should be either joint or it can be de novo. But then I respectfully said some guidelines to the effect that where this trial, most of the trial regarding the other co-accused has gone into like pronouncement, culminated, then of course the court should have de novo trial regarding this man who has been recently summoned, because it will be travesty of justice for the persons who are already facing the trial. So I was only saying about the guidelines in cases wherein at a later stage, almost when the trial is concluded, the summoning is there, then the court should at least have separate trial for these persons so that the trial is expedited for the persons who are facing trials for many years. That is what I say. So as far as this is concerned, now I come to the second point as to when the court starts looking at 319 application. Now here is a case where 319 application admittedly was moved much earlier to the pronouncement. It is around 2 months earlier. Now the word used is where in the course of an inquiry. Now course has been defined in Hardeep Singh's judgment from para 40 onwards. As to what is course, as to when court starts applying its mind. Now I'll read para 40 with Muller's permission. If Muller could kindly have para 40, Muller, page 121 of the judgment. Because judgment, Muller, that judgment fits in all the cases and is being rightly followed and right law. Para 40.
It's para 40.
Because Muller, word course.
Just 1 second, 1 second.
Please. Look, there are so many judgments, so I compilation. I thought the judgment is already.
Page 30 of my compilation.
I'll use Mr. Raju's compilation.
Page 30 of my compilation.
Yes.
That other compilation, it is there. It's there. I know it's there.
Somebody come here. Page 30 is there. Yes.
Well, let me kindly have para 40 minutes.
Yes.
Even the word course occurring in section 319, CRPC clearly indicates that power can be exercised only during the period when the inquiry has been commenced. Now, well, the inquiry I read in the section, inquiry into the offence, because there is a comma, inquiry into or trial of offence, indicates the power can be exercised only during the period when the inquiry has been commenced and is going on, or the trial which has been commenced and is going on. It covers the entire wide range of process of pre-trial and trial stage. The word course, therefore, allows the court to invoke this power to proceed against any person from the initial stage of inquiry up to the stage of conclusion of trial.
So that is what Mr. Bindra is up to the stage of conclusion of the.
Well, I'll read entire and try to convince the honourable court. Up to Mr. Patwalia, you pleased me. Please act on that also. I learnt a lot here. Now, I was reading para 40. Conclusion: the court does not become functus officio, even if cognizance is taken. So far, it is looking into the material for any other person who is not an accused. The word course ordinarily conveys a meaning of continuous progress from one point to the next in time and conveys the idea of a period of time, duration, and not a fixed point of time. Now, kindly have a next para also. In a somewhat similar manner, it has been attributed to the word course the meaning of being a gradual and continuous flow of advance by journey or passage from one place to another, with reference to period of time when the movement is in progress. So from the very first day, Millard, when the application is moved, this starts. Now kindly have para 42 also, Millard. That is also.
I didn't get what you meant.
Millard, this course is defined as Millard, I can again read, in somewhat similar, it has been attributed.
They already read.
Meaning, Millard, that a gradual and.
From the commencement of the inquiry,
Yes,
the question there was
please.
as to whether the power can be exercised only after the.
Next paragraph, Millard, I'll read 42, Millard. I thought I'll explain at 41 and go to 42, Millard. I was just trying to explain this
So
fact.
the view taken is that even prior to the trial being commenced,
Yes,
at the stage of inquiry also, the power could be exercised.
yes. Millard, it is course is that once, Millard, my submission is once an application is moved under 319, the court starts applying its mind. I am, Millard, on the fact that 319 application has been moved. It is said gradually from the very first day, Millard, the court starts applying its mind. Kindly have page 40, para 42, Millard, also.
Yes.
Thereafter, to say that powers under 319 can be exercised only during the trial would be reducing the impact of word inquiry by the court. Now, this court refers after 41 and 40 and 41 when court says once. Now, the fact contemplated by the court is if 319 is moved thereafter. So, the fact contemplated, although I'll be very fair that after the conclusion of the trial, If application number 319 is moved, it is in the air. It will not be taken up. But what the court says, Milord, when 319 is moved, the proceedings are pending, inquiry is going on, the court starts applying its mind, then Milord, para 42, to say that powers under 319 can be exercised only during the trial would be reducing the impact of word inquiry by the court. It is settled principle of law that interpretation which leads to conclusion that a word used by the legislature is redundant should be avoided, as the presumption is that the legislature has deliberately and consciously used the words for carrying out the purpose of the act. The legal maxim a verbis legis non est rescindum, which means from the words of law there must be no departure, has to be kept in mind. Now, I was only referring to this to show that the word course used in 319(1) is to the effect that once an application is moved, the court
of inquiry.
Yes. But I am only on the
Inquiry, and the course of inquiry precedes the trial.
The course I am saying in 319. I am saying if the definition of course is taken as mentioned in 319, I'll come to the reference. I'll come to that in a minute. I'll try to finish it, Milord. I'll come to that also, Milord. My submission is, here is a case where course, as mentioned in 319, is also defined in Hardeep Singh's judgment, wherein the court says, course means the application of mind. It starts and gradually goes on. So my submission is, once the application is moved, the court starts applying its mind. The time it is pronounced, the court has applied its mind already. So, Milord, I'll come to para 47, which was the only line Mr. Patwalia should have read for the reference, Milord, para 47, where, Milord, it said till what time?
He read the entire paragraph.
Yes, Milord.
Try to
He can read, Milord. I'm saying this is for the reference. I, Milord, restricted to the argument of reference only. Since after filing of the charge sheet, the court reaches, Milord, para 47. Since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the court frames the charge, the trial commences, and therefore, power under 319(1) can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of 207 and 208 committal, etc. So, Milord, here the Honorable Milord, the Constitutional Bench said that it can be till pronouncement of judgment. So, Milord, my submissions are twofold. One, I'll refer to the facts of this case, which are not to be referred. It is only the reference, Milord, of the question of law. I'll still refer to the pronouncement of the judgment as to how, in the present case, Milord, it is after the pronouncement that the summoning order has been passed. I'll refer to that also. But as far as the law is concerned, my respectful submission is, once the 319 application is moved, the court starts applying its mind. Gradually it applies. And if it is pronounced on the same day, because that is the reference, if it is pronounced on the same day, the judgment is pronounced. I will say, my lord, with my last permission, that it will be pronouncing at the time, my lord, because the judgments are signed on the same day, it will be pronouncing at the time referred to in Hardeep Singh's judgment. If it is thereafter, I am not saying about this case, my lord, I refer to this case. I am generally saying in all cases, because the reference is if it is pronounced on the same day. Reference is not that if it is pronounced thereafter. If it is pronounced thereafter, it has no significance at all. But if it is pronounced on the same day, the court has applied its mind. Court has applied its mind while giving the judgment of the co-accused. The court applies its mind and then comes to the conclusion that yes, while writing the judgment, while coming to the conclusion, giving a result of the trial, the court comes to the conclusion that yes, this man ought to be summoned on 319. The court can on the very day, same day, pass an order of 319 which will be covered by Hardeep Singh's judgment. This is my submission, not as well.
What happens to these words? Can be exercised at any time.
Please.
After the charge sheet is filed.
Please.
And before the pronouncement of judgment.
Lord, this is what I said. I'll come to Lord, I'll come to
207 and 208.
Lord, for that I said, the pronouncement of judgment, I'll say, if it is on the same day, that is why I gave a rider. If it is on the after, now only irregularity. If he would have pronounced 319 earlier on the same day, it would have been valid. So I will say only irregularity as mentioned in 465. So I will say, it's a case because I am only emphasizing on the fact if it is on the same day. If it is pronounced on the same day, the application of mind started, the time when 319 applications are moved, the application of mind started when he started applying his mind to the facts of the case, pronounced the judgment, and thereafter, if it is taken that after the judgment, the pronouncement regarding the application of 319. Now, let us come to the present case. As far as the present case, it's crystal clear that the pronouncement of judgment, as already referred, is when the sentence is passed. Now, what happened in the present case is the court convicts them. Court convicts them because they are on bail, they were present. Now, thereafter, the court passes an order on the 319. Then the sentence is passed. Kindly have. So, there's a difference in the present case. What the court does is, I'll read the order of the court wherein the summoning order is passed. Court says, I have convicted. Court has not said, I have convicted and sentenced. Because after conviction, the time is given to the accused to come and explain about the sentence. They are given an opportunity. Now, after lunch, when the court's date is the same, kindly have the order passed of 319, where the court says it is convicting. I have convicted. Court doesn't say that I have sentenced. Page 130,
Volume 2.
It is in the SLP. Volume 1.
No, R3.
This is 9063.
By 547, 120, no? Oh, beyond what?
This is the SLP,
Mr. Advocate General,
Please,
once conviction order is passed,
please,
sentence is different aspect.
please.
Trial comes to an end.
Please.
Now, the language employed in 319(1) is in the course of enquiry, trial. No, it may be a technical argument. We understand that, and we can't decide. Justice is according to law.
It has to be.
Justice according to law is as old as the hills.
Please.
It is said.
Please.
Therefore,
Please.
what is the law? In the course of the trial, enquiry or trial comes to an end the moment judgment is passed and not sentence.
Well,
how do you react?
My submission is the court is not functus officio at the time because it still has the power to pass sentence.
Read the language employed here.
Yes, sir.
Again, if you want. Let us read 319 again.
I'm reading Hardeep Singh's judgment
Three-
because Hardeep Singh has elaborated
Where in the course of any enquiry into
or
trial of an essence,
Please.
it appears.
please,
So here
trial.
it is it is super technical about what to do.
The trial has been
Maybe the magistrate, the concerned judge must have committed an maybe.
that is why I said, kindly appreciate. Hardeep Singh's judgment has tried to say what the trial means. It says from the time of charge sheet
Trial, there is no distinction. They said they have only construed words
till pronouncement.
inquiry into,
Please,
and they said that it has a wide scope.
please.
Trial, there is no difficulty. Trial would start once they.
Yes, I am on
charges are framed thereafter.
I am on para 47, wherein the court has said that 319 can be moved or decided till pronouncement of judgment. So, here I say pronouncement of judgment will be with the passing of sentence. With passing of conviction order, it is not pronouncement at all because the court is not functus officio.
But trial has come to an end.
Blood-
The language employed.
Blood-
in 319.
The court has still to apply its mind. Hardeep Singh's judgment, I'll refer again, para 47.
No. Thereafterward, limited application of mind.
Still he has 1%.
When the words itself you say that during the course of any inquiry
And or trial.
Please,
or trial.
please.
End of the matter.
Then it will come to conclusion of trial, which is not the law, which is not,
That is what in para 40 the court says.
47. Kindly,
You can't read it in isolation. One
I will not.
Mr. Advocate General,
Please.
Hardeep Singh is not a statute.
It is not, it is not. But then, the question will
Therefore,
be,
you can't pick one sentence from here and there. It has to be read in the context.
yes, my submission will be, if the trial, it is said to be trial, my respectful submission is trial will will come to end only when the court becomes functus officio, after it passes the sentence. Before that, the court will sit down, take up the file of the session case and will pronounce the orders. So, I will say, if technicalities are to be taken into account, the technicality will be the court still has the power to sit down and decide about the sentence. So if the court has the power to deal with the file I will say the trial is still pending. It was conviction order, wherein after that, I'll read the summoning order, wherein the court passes the summoning order thereafter, and then the sentence. So, my lord, the court, when was dictating the judgment or applied its mind,
We have Tingari. You see, 231.
please,
Evidence of prosecution.
please.
Then thereafter, as Mr. Nagmatu put it 232.
Please.
So 232 doesn't arise, then 233
Yes, sir.
entering into the defense.
Total, please.
So once the evidence is complete, normally the trial would come to an end. Thereafter, what is left is only arguments and judgment.
My lord, after, this is in case of acquittal, my lord. But in case the court finds it's a case where the acquittal is not made out, 313 will be recorded, defense witnesses will be recorded. It's a,
That's why we are stretching, Mr. Advocate General, right up to the pronouncement of the
my lord,
judgment.
I, with respect, I'm trying to stretch it till the sentence, my lord. Because this is what Mr. Nagmatu also said, my lord, and this is the right law.
Against you on
My lord, just I'm taking, my lord, from the thread where he left it. So, my lord, he also said, and rightly so, till the sentence is pronounced, and Mr. Patwalia agreed to that on that, at that context. Yes, it is only when the sentence is pronounced that the trial comes to an end. Maybe, my lord, he now changes. But then it was, my lord, just
Sir, tell us on facts, though it may not be necessary for us. Tell us on facts, Mr. Advocate General. Now here judgment is pronounced. Thereafter, 319 application is allowed, is it?
yes, my lord, only one section of invalid permission I read.
No, you have material to support that?
My lord, material to support in the order passed by the court summoning under 319, the court refers to that he has convicted. He does not say he has convicted and sentenced. I'll read that order. That order was read, my lord, and refer to that conviction is there. I can read with invalid permission.
What is the offense here? What is the offense?
NDPS.
So generally, NDPS, how do they pronounce the judgment together? Is it?
No, my lord, quantum is separate, my lord. What is,
No, but it requires material, no, for that. There should be an order sheet maintained to that.
Well,
I have pronounced the judgment.
I will-
Otherwise, here you.
I will submit. I will.
Generally, in this type of cases, to my knowledge, judgment.
It's the same order with.
It is all right, Mr. Patwalia, let me know. It is not the same order.
Same order
It
with
is not. Kindly see, it is not, my lord, with respect. It is not. I'll just, my lord, it is not, because in the
Whether they were heard for.
yes, my lord, let me submit. My lord, in the conviction order, they are on bail. In sentence order, they are in custody. How does he say it is the same order? It is not. They are taken in custody and thereafter sentence, they are heard on sentence. I'll read the order. It's a separate order, my lord. They are on bail on the conviction time, and then they are taken in custody, called for hearing the sentence, and then sentence is passed. It always, when the judgment we receive is last page of the sentence is attached with the conviction order. So you can't say it is passed at the same time. Always, a order of sentence is attached to the order of conviction.
So the last sentence of the judgment is, now I shall hear them on sentence.
Yes, my lord, yes.
In this judgment.
My lord, yes, I'll read. Further, it is proved that file so and so non-commercial quantity, let accused be heard on quantum of sentence. And then, my lord, the order in which they are taken in custody, they are heard on sentence.
In the meantime, you said 399.
Yes, because, my lord, in
Oh, no.
my lord, I will try.
Possible.
My lord, it is. Kindly, I'll read 319 order. I'll read 319 order. Let me read, my lord, 319 order, where the court says, now, my lord, it is, my lord, with respect. My lord, they are taken in custody, brought again, then only, my lord, kindly have, my lord, the order, where the court says.
Advocate General, for pronouncement of the judgment, they should be brought to the court.
Yes, my lord.
Judgment is pronounced.
Please, my lord.
then the judge says, all right, now I will hear you for, on sentencing.
Please.
Heard and sentence imposed.
Milord, it is separate order, separately passed. It is, Milord, most of the time.
Same day.
Same day, Milord, most of the times it is after lunch. Most of the time, 99%. It is never, Milord, on this at the same time, never. They are given opportunity to put their case and,
What you are suggesting, the pre-lunch session, as
Yes.
discussed earlier, judgment.
Milord, what I,
Thereafter, after lunch, 319 application.
No, my lord.
After tea, sentencing.
this is what my friend had argued, Milord, that it is after tea. The other case, Milord, he had argued that this is after tea at
Maybe
4
you
o'clock.
must have taken tea first and then lunch.
So, Milord,
Resume tomorrow,
Milord,
right?
if we feel an urge.
53, judgment is.
This is
After page 109, the quantum of sentence and everything is in continuation.
It is continuation. It is uploaded together, Milord. What happens is, conviction judgment is passed and the order of sentence is uploaded together in all the cases. So then it is attached with the main judgment.
Let's come to an end.
On what basis do we say
Please.
that the order under 319 was passed between conviction and?
This is what I was reading. I can read with my permission without Milord, taking your lordship to the page.
I have convicted.
Yes. The order says, I can read Milord
You want
319.
to take the word of, take advantage of the non-use of word sentence.
Yes, Milord. The court would have definitely mentioned. Definitely
Mr.
mentioned.
Advocate General,
That goes
just
against
read
the.
353, then we will, just read 1 second, 353 you read, just 1 second, 1 second.
How do you reconcile section 353
Read
with
353.
section 319?
I will, Milord, kindly read 354 also. Milord, I'll read 353.
Then we will do it tomorrow.
actually,
Milord,
it
only-
is much ado about nothing. The moment he even.
Mr. Patwalia, if you can take 2 days on facts
Yes.
without going to the reference, I
Yes.
can take 10 minutes off.
Yes. No, I'm not against your 10 minutes.
So I'm only, Milord, I'm only trying to
Mr.
put my.
Advocate General, we will provide you as much time.
I'm so grateful, Milord. I'm so grateful. I know.
Absolutely no problem.
I am, Milord, so obliged. I am so grateful. I know that. Milord. I know that. This is the opportunity which I got. I never wanted to miss.
After Nagamuthu. Let's fight for you.
We may not take more time like this, because it's a small matter.
Yes.
That's a corruption case.